Hey, folks, good evening. Happy Friday to all of you. Welcome to Friday Night Frenzy, where we talk about all the things that happened in law, well, that I was able to cover over the past week, in this case, 2 weeks. How you guys doing? Happy Friday. We made it to another week. We actually made it to the end of January. So, cheers to all of you for successfully surviving the first month of 2025. So, how you guys doing? What are you doing? How's your week? What's going on? Let me hear from you. Let's talk to you guys for a little bit. We've got a lot going on, a whole lot going on today that we've got to cover. And I actually got a new topic that I was trying to research just briefly before jumping on this stream. So we're going to talk about a case that we have not covered or looked at. So I was trying to figure out what the case was about. And of course, as always, I have to thank the recovery addict, Scott, and Calypson for just drawing my attention into something that, of course, not at all curious about anything else. Anyways, how's the weather where you are? Are you staying warm? Is it warming up? Is the snow melting? Is there snow at all? Tammy Issa over Karen Reed. We're going to talk about it briefly. I mean, it was a weird hearing today. And I got pretty frustrated halfway through the hearing going, why are we here? So we've got that to talk about. We've got New York doing some New York things. And we've got all kinds of stuff going on. Samantha, yeah, you're live. Need a break for my legal business class in the case I'm writing about. I'm curious, what case are you writing about? That's cool to see. Huh, that's really fun. Pamela Weisenbach, prayers for you. My father's in the hospital again, but he's bitching about it, so he's likely fine. It would be remiss of me not to mention something that occurred this week in an area that's very, well, those of you in the United States have undoubtedly seen the news by now. And I'm going to touch on this briefly because it's been bothering me all week long since the news occurred. 2 days ago at Washington, DCA, Reagan National Airport, an aircraft collided with a helicopter while it was in the process of landing. That aircraft carried, I believe, the total number of, I think it was 70 souls on board. And there were no survivors, including the 3 that were on board of the Black Hawk helicopter. It has been a remarkably significant impact to the community here in the DC area. While this area is vast, it is amazing how interwoven the people are and how many people we intersect with on a daily basis. A lot of very young folks had their lives cut very short. And it, from what we can see, is just a tremendous accident. All circumstances, everything that could go wrong did go wrong. So just want to mention that because my prayers are going out to everyone affected by this, all the families, friends. It was absolutely tragic. And I have flown into that airport. I cannot even tell you how many times. Landed on that runway, which is actually very rare to land on that runway. And I don't even tell you how many times that is a scary runway to land on. Absolutely horrific to think about and to replay kind of your own process of landing on that runway. And then all of a sudden you're in the air and all of a sudden you're not. So it was remarkably tragic, absolutely remarkable tragedy. And if you have a second to lend a prayer, lend a thought, please do so to all the families who lost people that were very close to them. A lot of kids too. And athletes, young athletes with aspiring futures, educators, lawyers, parents, siblings, uncles, aunts, grandparents, any number of people that were there. So, like I said, prayers go out to everyone involved. I don't know. I understand that today there was also an incident in Philadelphia where a medevac Learjet just crashed into a. There's a whole lot going on that's remarkably tragic. So if we can act a little bit more graceful to one another, a little compassion to each other, it'd be really great. And, one of the ways we get over tragedy is talk about things that aren't tragic. And that's kind of where we talk about things that are, calming, usually, like the law. So cheers to all of you. If you can raise a glass, raise a glass. If you can lend a prayer, lend a prayer to the fallen. May you find peace wherever you are. Okay. Now that difficult moment is out of the way, not to say it that way, but now that difficult moment is out of the way, let's chime in, see how people are doing, and start getting to topics that make us a little bit less sad. A little bit less sad indeed. Laura M., your father had an airstrip and a plane, right? Yeah. My dad was a single engine pilot, Blue Bonanza, Cessna 172, various aircraft throughout his life. I grew up very familiar with aircraft, not of that scale or size, but airports were, daily occurrences for me. So it's very weird. It's a very weird thing. It is very rare that those incidents occur, and to have one of that significance is pretty tragic. So let's go on, catch up on some of this stuff. In happier news, you guys want to see something funny? Well, do I want to share this right now? I think I do. We're gonna laugh. We're gonna bring up a little bit of news. We're gonna laugh about something. For those who are going to ask, because I know you will, Ian is tied up he's recording a podcast or doing a live podcast right now. And he's already told me he'll be here a little bit later. So that is what we're dealing with. Okay. I'm going to check my phone first because I was waiting on a message. Okay, here we go. This is what I was waiting on. I was waiting on Mischief Manager to send me something. Actually, photos, because one of the reasons I was late today is we had lovely family dinner at Uncle Julio's after rushing from work to get to this location to eat, then battling the parking lot, which entailed going around and around in circles for multiple times to try and find a parking spot. And come to find out, towards the end of dinner, I discover why this location was chosen, why this establishment was the establishment of choice for the family, and why we were going to eat there. And it was because of the dessert that they served. I was unaware of this, but did you know that they serve a chocolate piñata? A chocolate piñata. Yes, I recognize that I said chocolate. Sue me. Don't literally sue me, but just yeah. And this chocolate piñata is not listed on their menu. Nope. Not on the menu. It is, however, assuming this thing can actually save, located on the website. So Mini-Mischief 1 is apparently the reason why we had to go to this restaurant. Because she saw this chocolate piñata on the website. I'm currently waiting for the photo to download so I can share you guys. So I have this full meal. Mini-Mischief 1 has these 2 tiny tacos. Manager has a bunch of stuff. Mini-Mischief 2 was doing Mini-Mischief 2 stuff, which means he was in a little bit of a mood this evening. But the tiny little tacos were just gone off that plate in 2 seconds. I was convinced this girl was just going to be starving for the rest of the night. And then it came time for the dessert. And my first learning of what the dessert was, what the intention was with regard to that dessert. And man, oh man, should I have been more prepared. I was not prepared. Because the size of this thing, one, they give you a club. Like they give you literally like a wooden stick. It's like this big. It's not small. So it comes out with they pull out this club and you get the fondue sticks. You know what I'm talking about? Little forks that are long. And yeah, exactly, Laura. A Hurdy stick. Yeah, you get a Hurdy stick that is there and it's presented to you. So you see the size of this club come out before any of the food even makes its way. So you're already kind of freaking out. You're going, there's no way. There's no way. What is this thing going to do? How big is this thing going to be? how can I get this thing on my computer? You know what I'm going to do? No, I'm not going to do that. Come on. Now is the moment when it decides it wants to be a pain in the ass. Every time. Every time. This is streaming. This is dynamic. This is what happens. This is why we get into trouble, because we end up getting distracted. The distraction becomes the main focus. And then all of a sudden we're lost. We're in the weeds, folks. We are in the weeds. All because I can't find a photo. I mean, not really true. I can find the photo. I just can't, present the photo because I have to get the photo off of my phone and on my computer. Get out of my phone. Get on my pooter. So we're going to try it this way. Did I take my meds today? Yes, I did take my meds today. We have Le Ultra Focus. And everyone's already a step ahead of me. Yes, I emailed it to myself. I just did. And that was always the right choice, apparently. So that's what we got. This one. We have the one. We have the two. We have the three. So how do we go about sharing these? We do it like this. And it goes a little something like that. And this is why we do these things ahead of time, because things get confusing. They get confusing. And you get lost in the things you're searching for. So what you do is you keep searching and you find what you're looking for. Yeah, there we go. And share screen. No, listen, I said share screen. That is the table. That is the table. That is the chocolate piñata. Yes, it was massive. Yes, it was remarkably crazy. And yes, it took at least 3 hits with the wacky stick to break it. And when you break it, that is the goodness that's inside of it. So now I understand why Mini-Mischief 1 wanted to go to Uncle Julio's, because she wanted to take the wacky stick and she wanted to hit the big chocolate ball and make the chocolate ball explode where strawberries, pineapple, and churros would come out of it into like homemade whipped cream with chocolate dipping sauce and caramel dipping sauce. So that's why those 2 little tacos were gone off that plate, completely decimated. And then when the request or the question was asked, are you still hungry? Would you like food? That was the whole plan. The entire plan was to get this thing. And then we had an ongoing debate about how much this thing was going to cost as it was being delivered to us, because it's not on the menu, so you can't see the cost of it. You just kind of go with it. And we had a debate, whoever was closest, whoever was furthest away was going to have to pay the bill. And Mini-Mischief goes, well, how am I going to pay the bill? And I said, you can work in the kitchen for a little bit. I'm sure they can use a dishwasher. It was so good. It was so awesome. Definitely worth it. 100%. Do not regret. Absolutely recommend. And there's the aftermath. How much was it? strangely enough, this whole massive thing of dessert that I expected to be something like $45 was $35. Which is ridiculous. I understand that. I completely understand that part. 35 US. But you only do this once. If Mini-Mischiefs is watching, you only do this once. We're not doing this every week. No, 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 no. We're gonna be po. You can't do that. But considering it's that much chocolate and fresh fruit and the churros are legit too. Yeah, it's pretty good. It was amazing. I thought it was a great idea, a great way to end an otherwise challenging week. And I'm currently, I don't know if I'm like in a coffee high where there's the caffeine is just starting to make me a little jittery or not. We're going to go with that because it might be the case. But that's where we are right now. So that was this evening's plan. That was fantastic. It was a lot of fun. And it was a great time had by all. So let's catch up on some chats. I don't know, what was your guys' favorite desserts? You remember the dessert trays when they would bring those out? Like they'd wheel it out on a cart. You'd have to pick. Those were great. My favorite go-to is always creme brulee. Oh, you know what? Do we do a poll? What are people's favorite desserts? But I get to choose what options you have to go with. Yeah, let's do that. I'm going to put a terrible choice in there too. No, I'm not going to put a terrible choice. I'm going to put a legitimate choice that you guys can pick. I think. And we'll just go with that. So let's see. What choices shall we put in here? Let's go with. Now, the thing is, I can't go lemon meringue pie or this other stuff because it's not one of the most common thing in the world. So we're going to go with some pretty simple questions. We're going to say favorite, and I'm going to caveat this one, favorite dessert at a restaurant. Now, dessert is one of those words, and dessert and desert is one of those words I still, practicing lawyer, still misspell from time to time. So did I just check in the next Google tab over the correct spelling of the word I had and to make sure I was right in spelling this word before I posted to the chat? You absolutely bet that I did. 100%. So we're going to go with cake. I have a chocolate cake, but I'm going to do the cake. Cheesecake, because, reasons. Then we're going to go with, we can do, tiramisu is pretty. No, we're only going to do 4 options. So we're going to do ice cream sundae, which can be, with that option, you can basically imagine your favorite ice cream. And then I'm going to say creme brulee because, well, again, I own the stream. I put up the poll that I want to put up, and that's what I wanted to choose. So the poll is there. You guys can vote. We'll come back and check on that in a bit. Because I always get curious. Personally, my dessert of choice happens to be liquid in nature, and it happens to be just a really good red wine. If someone at the table has chocolate, wonderful. But just a nice glass of red wine, I'm happy to just let everyone else enjoy their dessert. I will enjoy my liquid dessert. That's always my favorite. Okay, let's catch up on some chats, get to our first topic, because I promised that I would get to that topic before Recovery Addict had to go to sleep. Because, I don't blame him for not wanting to stay up until however late I stay up. And catching up. XCDA, glad to see everyone. Frozen pizza from me with a lovely homemade lemon drop. That sounds fantastic. Light Queen, good evening from Van Isle, Canada. So nice to catch a live from the start and not 2 hours in. I'm glad to see you here. Vez, glad to see you, Vez. Finally catching a live. Missed you too, Vez. Glad to see you. Gotcha. Thank you for gifted memberships. Much appreciated. Just because. Thank you very much. Don't forget to like on your way in. Everyone, happy end of January. The running joke throughout the entirety of last year was that I still thought it was 2023. It is no longer a running joke. It is now just reality. I still personally believe that it is 2023. So that is where I am right now. But instead, it's already February. I've got trials coming up too. My trial calendar does not look friendly. DSN, thanks for the membership to whoever gave that to you. So DSN's thanking the community. DSN then turned around and gifted memberships themselves. Thank you, DSN. Emily Aarons, this week felt so long. Happy to unwind with FNF. Thank you. Anyone else? Anyone else in the room? Raise your hands. Yes? Long week? Kind of like didn't realize that it was just 1 week and not a month? That was me. That was my feeling the entire time. Sending a note real quick too. Someone, just because the Collin Griffith case brings up so many questions that I wish you would comment on. So many fail safes. That is, I'm very intrigued by this case now. So I don't know that I have the capacity to cover the whole thing, but when I got this question, I was very curious instantly as to how that question came up. So we're going to go through it, and I want to watch that bit. I'm going to do it at the beginning of the stream. Light Queen, our first snowfall of the season should be starting tonight. Island weather is nice. Well, we are just getting rid of ours with some heavy rains or some drizzling rain that happened all day long. So cheers to snow, I guess. Blue Cat, thanks for being a member. AG, New York Times reporting says it was likely due to a single person being instructed by a manager to handle the ATC duties by two people. It was preventable. Almost every single accident is preventable. That is a failure. It is not the only failure that transpired from what I'm understanding on the ground. I think this is going to be an investigation that's going on for a long time, and we're going to hopefully find out what occurred so that we can fix it. Not so we can cast blame, so we can fix it in the future. AC's Wildflower. Jan, has been a long month, and a reminder to craft helps. Always reminding you guys, get outside, get in the shop, make something, have fun doing it. Recovery Addict PSA, Sprite flavored Tic Tacs are not good. Ew. That's horrible. Why would you do that to yourself? Bad, Scott. I'm an orange Tic Tac person. I like the orange Tic Tacs. Karen, did my email make it to you? Yes, you did. Yes, it did. I got it. I did get it. So that's going out this weekend. Monica C, I'm pancake and I pooped 3 times today. I'm a Great Dane. Oh, you're in the avatar. I pancake the pup. Pancake the pup can probably hear Leo the pup outside. Maybe. I don't know. Fiona W, thank you for gifting memberships. Very much appreciated. Jen DeSimio, thank you. Hi, from rainy Northeast Ohio. Crochet and law are a great combo. They are absolutely a great combo. Unless you're actually practicing law and doing the crochet at the same time. In which case, not the best combo. Godtree, so am I the only soul on this planet who finds law calming? Thought I was alone with that thought. Thanks, Rob. I like logical. I like being able to break down an argument and remake it or fix it or argue against it. It's calming. Not to other people, but to me it is. Laura Christine, thank you for gifting memberships. Quinny Bly, thank you very much. My munching and got promoted. Given a businessman. So proud of my munchkin. Got promoted and given a, I'm guessing that says business meeting. Congrats to the munchkin. Absolutely congratulations to the munchkin. Zimmy, thank you for becoming a member. Puppies and Pizza, member for 1 month. Thanks for being here. Awesome to see you. Also love the avatar. That's cool. AG, happy news. I'm down 11 pounds in 7 weeks without dieting. AG, that's remarkably happy news. Also, I hate you. I mean, congratulations to you. 100% congratulations to you. But also, I don't like you. More out of jealousy than anything else. Because the month of January has not been kind. But congrats. That's really cool. Analytical Blarney, Sandy, thanks for all you do. The real MVP, Sandy, and all of the mods. Every one of the mods are really awesome at what they do. They do a great job of getting me from start to finish relatively focused and on time, and all the stuff they do in the chat to keep everything moving forward. ADHD Jelly Bean, Law Nerd, may I have a cheers? I started my new position as a youth peer support worker this week. Wanted to share with chat and celebrate. You can absolutely have a cheers to that. Cheers to you, ADHD Jelly Bean. Way to go. I hope the position, I was fun. I was rewarding. It's going to be challenging. I was rewarding too. Okay. Oh, that's funny. I just said K. And it popped up as K. K. Thank you for the super chat. Farrell's Ice Cream Parlor, the Zoo. Is that a place? Farrell's Ice Cream Parlor. I don't know things. Portland, Oregon, 1963. Chain became defunct following the closure of last three in Brea, California, 2019. Oh, that place looks fun. Very cool. Goody Blyce coming back. Chibi chat. God, wanted to share a celebration. My munchkin just got promotion and given keys for business. That is definitely worth congratulations. Congratulations. Jane Stoddard, enjoying your stream and team. Happy 2024. Happy 2024 to you. CSI Canton, our methodology equals red solo cups. Get over it. Why was today a hearing? I don't know. It was funny to watch. JDT, character girl. Hi from Oz Rob. Sent portrait to our shadow Leo. I will make that known to Mischief Manager who runs that. So we'll absolutely make her know of that portrait. Baby steps. Thank you for gifting memberships. B. Hartling, I turned 50 this year and I'm so not ready for that. Every year is one more year wiser, and you can still have just as much fun as the year prior, just in different ways sometimes. Elizabeth Love, I'm in my final semester of law school and getting ready for job interviews next week. Wow, good for you. I'm writing a research paper on financial abuse. Could I email you for your perspective from practice? You can absolutely email me about that. I have a whole lot I can tell you about that. Wow, yeah. Law and lumber spelled out at gmail.com. Absolutely. Comes up all the time. I mean, I've got a case of it right now. It's difficult when I'm in active litigation, can't give you the hypo, but when I'm not, I can oftentimes send after the fact. You know, if the paper's there, I probably bring up just a topic to talk about for when it takes place. I mean, it happens enough. It's remarkably sad when it does. Let's see. We litigate a lot over it. Luna Santiago had a heart catheter Monday. Today was iron infusion. Hope the infusion went well. My best wishes to you during that process. That sounds like quite the ordeal. So I hope you're happy, healthy, and healing. Cheers to you. Lady Fang, have you seen the MA versus Penny McGee from Canton? I have not. I can take a look and see if I can find anything about it. Suzanne from Australia, thanks for becoming a member. Analytical Blarney AB, thanks for becoming a member. Ryan Man YYC, fear not, the FAA will not rest until they have clear evidence of pilot error. The FAA is one of the most complicated beasts I have ever come across. Let me give you an example, right? So my father died of cancer and underwent chemotherapy in doing so. Chemotherapy has some pretty tremendous side effects, right? In that you gain nausea, you can be weary, you can be tired. There's a lot of side effects, okay? My dad would clear FAA medical even with the chemotherapy. However, if my dad happened to be diabetic, and even if he had an insulin pump, if he happened to be diabetic, he would not have cleared his FAA medical. Tell me how that makes sense. Some of the rules in the FAA are so arbitrary that they're just there, and they wield them like a massive sledgehammer. So are there rules that need to be in place to maintain safety? Yes, Absolutely. Do we need to revisit those rules from time to time to make sure they still make sense? Mm-hmm. The FAA is a beast, an absolute monster. Carolyn Knight, PSA, cats can start fires, put obstacles on stove. Oh yeah, do that. Cats are mischievous as they are. Kate Cap, teacher here. You want 2 desserts, 1 desert. You're welcome. 2 desserts, 1 desert. You know what's gonna be really funny? Really funny is I will probably be in court writing something or at office writing something in a formal pleading, and will remind myself of that in the process of writing that word. I still say MISSISSIPPI when I write out Mississippi, which is very rare. Blessed in Texas. Thank you. Following chat is stressful today for my brain. I'll be watching though. Happy FNF to you. Blessed in Texas. J. Michael RN, glad to join you for the night. Had a great day with great friends. Got to catch up on IG sometime. Absolutely, J. Michael RN. I actually have to be on it. I haven't been on Instagram or had time to be on Instagram in forever. I got to do that. Would you guys like to see some of the 3D printed stuff on IG? I've always wondered that. It feels like cheating because it's like files that I'm manipulating rather than doing the true design. But it's really cool stuff. Let me know. Jill Moore, relieved, has got good results from breast cancer test. That is phenomenal. I know that was freaking you out last time we talked. The lump is benign. So happy. January stressful. Congratulations. That's great news. That must be such a relief. Nancy Robbins, I'm getting married in 2 months. Congratulations on the nuptials, the pending nuptials. Absolutely. My gosh. Look at this. Celebrations abound. Jinx Clemens, good night all. We'll do replay 3 a.m. in Denmark. Absolutely good reason to tune out and do replay crew. We love the replay crew. If you are on replay, please leave a comment, like the stream. If you're watching live, please like the stream. You will notice, those of you start the stream later, I have been turning off monetization throughout the process of the stream, so you guys aren't getting hit with these, endless advertisements that are getting populated during the course of the stream while I'm streaming. So I've been turning off monetization while the stream is going and then turning it on when it's done so that it's not distracting you guys when we're talking about topics like this. All right. So, crack the neck. That felt weird. A little bit weird. And before we jump to our first topic, I am being respectfully requested. Oh man. Really? I gotta do a code. Is there a way to hyperlink with that code if I plug that in? Let me just double check something. So my paralegal, whom you guys know I cannot survive without, her daughter is having her Girl Scout cookie sale again. And it has been requested of me by the person who, makes it possible for me to do my job, makes my life somewhat normal. Hang on. Let me see. No, not that. Has requested that I go ahead and post the link to Girl Scout cookies. So if you guys are ordering, if you have a desire to order Girl Scout cookies, which are delicious, I know that we just AJ. This is not for. This is not. For, this is sorry. This is not for you. You just celebrated losing 11 pounds. I sorry. This is for people like me who just are in the I don't give a crap mentality right now. If you are not in the process of trying to lose weight and diet by not eating delicious Girl Scout cookies, then please don't do this. Or if you do want Girl Scout cookies, and I'm going to post a link in the chat. I'm going to pin it at the top so that you can You can see what you guys did. What you guys did last year was remarkably wonderful. What it did was that it paid for my paralegal's daughter to one, get her enrollment again in the Girl Scouts for the following year, which is awesome because it helps people out who don't really, it's great. Two, the Girl Scouts is a phenomenal program. I still love what they do. I still think they do a great thing. Three, the cookies are delicious. Four, it makes my paralegal happy, which makes me practicing law and me going to trial very happy. And five, it got her a pair of really cute Crocs. So I'm going to go ahead and post that link and then pin it to the top of the chat. So let's find where we are. Try this. Make sure that when you do this, make sure that you select ship to me. That is going to be one of the things you got to pick. And then let me know if the link is dead, please. You got to pick delivery option though. Deliver my cookies. Deliver my cookies. So we'll check back on that and see how we do. Mini-Mischief isn't in the Scouts. Not yet. I'm still figuring out what we want to do extracurricular wise. And then we'll check on the poll and then we'll go to our first topic. Shall we? Lone Star Living, thank you for the super chat. Very kind of you. Zam, good morning from the future. Hope everyone's doing fine. Glad to see you here. Zam. Terry Lou Beth, lost my father 4 years ago. My mom is making me a quilt from his dress shirts. I'm taking all the buttons and making fidget things for his grandchildren. They are in their 30s, so not a swallow danger. That is amazingly cute. I had all of my dad's dress shirts too. I still wear some. I wear one or two of them. So I have some of his polos that I wear in his jacket too. Stuff's really, it's important. You never realize it, but it really is. Adrian Jameen, thank you. FAA RE diabetics. As a diabetic with insulin pump and CGM, I often show poor thinking ability before I am alerted that there is low blood sugar. So I hate to agree with the government, but they've got a point. Point given in some respects, but there's other rules on the FAA medical that just don't as much make sense, especially when you're talking about, I think it should be more case by case specific. So we've got 1,000 votes in the poll. Let's go ahead and end that. The poll was favorite desserts at a restaurant. We had 4 options: chocolate cake. 4 options: chocolate cake, creme brulee, cheesecake, and ice cream sundae. Of the 1,000 plus voters, 40% of you said cheesecake. I know where Mischief Manager lands in that. That's cheesecake is her deal. 25% of you said creme brulee. You agree with me. 21% of you say chocolate cake or just cake. And then 12% say ice cream sundae. You know, the cheesecake beating out the creme brulee and the creme brulee beating out the chocolate cake, I thought is interesting. Learn something new every day. So, all right. First case we're going to talk about is the case of the state of Florida versus Collin Griffith. So I figured the best way of getting our hands wrapped around this case was actually just to read the indictment. It's 5 total pages, relatively simple. And then we'll get into some of the stuff we talked about today. That was talked about today. Oh, sorry. I am forgetting that I have to swoop. So we're going to swoop. I have not made a Leo swoop, so you get this. Double swoop. Okay, so in the circuit court for the 10th Judicial Circuit, Polk County, Florida, state of Florida versus Collin Griffith, the indictment, 2 counts first-degree murder and kidnapping. In the name and by the authority of the state of Florida, grand jury presents the following. Collin Griffith, on or about September 8th of 2024, in the county of Polk and state of Florida, did unlawfully, from a premeditated design to effect the death of a human being, kill Catherine Griffith, a human being, by stabbing said person with a knife and during the commission of such felony, the defendant carried, displayed, used, threatened to use, or attempted to use any weapon in violation of these sections of Florida law, contrary to the form of the statutes, blah, blah, blah. So we've got a first degree murder. Count 2. Collin Griffith, on or about September 8th of 2024 in the county of Polk and state of Florida, without lawful authority, did forcibly, secretly, or by threat confine, abduct, or imprison Catherine Griffith against her will with the intent to inflict bodily harm upon or to terrorize her or to facilitate the commission of a felony. So that's the underlying premise of this particular case. And I know that that's just a snapshot because there's a lot more going into this than I can really explain. Here's the general synopsis. General synopsis is 17-year-old child, and yes, 17-year-old still minor. Okay, so 17-year-old is accused of killing his mother after she bailed him out for killing his father. How does that transpire? So he was serving time for killing his father, who was age 43 at the time, on Valentine's Day in 2023. He had a claim of self-defense. Prosecutors released him the day after that they couldn't prove. So Florida, you remember when you have a self-defense, the prosecutor has to put on a mini trial to basically disprove the claim of self-defense before they can go forward. So the prosecutors couldn't disprove his story that his father pulled a knife on him and chased him, and that his actions in killing his father were in self-defense. So he ends up getting released from jail. So the jail staff reported that Collin had threatened to kill his mother if he had to get in a car with her. And again, he was released. What day was he released? I don't know a whole lot about this case, so I'm coming into this fresh. Anyways, gets in the car with his mom, and then Catherine Griffith, his mother, was killed on September 8th of 2024. Collin's claim. Wait, is that really his claim? His self-defense claim? Collin's claim is that he called the police saying that his mother fell on a knife during an argument. I mean, that seems a little thin. But one of the things that was very curious to me was this question that I received. And it was a question about privilege and whether privilege attaches to certain communications. Let's go here. All right. So we're going to watch a little bit of testimony leading into the question. And you're going to get an idea. Now I'm watching this original argument fresh. I have not watched this argument before. I simply listened to some of the back and forth of it a little bit later on and was giving my opinion of it to Scott's stream. So I'm very curious to see what was argued here. And then we can go to the ruling, because this was from a day ago. And then the judge heard additional argument today and then made a ruling. But we're going to use this to kind of have a good discussion on the topic of privilege. So let me know if you can hear.
I remember the text message.
Okay. I'm mentioning these page numbers based upon what I saw. On page 4 of 8, did the mom text her son, "Your phone service is disconnected"?
Yes.
On page 8, did the mom text her son, "You have 5 minutes before I deactivate your cell phone"?
Yes.
On page 1 of 29, did mom text the defendant, "I'm turning the phone off after this. Please return my cell phone and MacBook"?
Yes.
And regardless if she was going to follow through with her threats, the defendant obviously knew who controlled the cell phone, correct?
Yes.
Judge, I'm going to object to that statement because there's a difference between the service and the actual phone.
Starting to lay the foundation. Oh, Kaylee, good point. The holding he's emerging from is not the father's murder. It's a Baker. He was Baker acted? Interesting. Fascinating. Okay, so we've got a distinction between the service and the physical phone. And Scott, if you're watching, if you want to jump in and give people a synopsis, you are more than welcome to do so. Just send me a text and I can get you on, but I don't, it's again, invitation, not expectation, always. But RA peeps are usually here. And I know a lot of them have been watching this trial. Okay, so let's rewind a little bit and catch up and get back to this argument. Baker Act is an involuntary commitment. It is basically you're on a mental health hold.
The defendant, I'm turning the phone off after this. Please return my cell phone and MacBook.
Yes.
And regardless if she was going to follow through with her threats, the defendant obviously knew who controlled the cell phone, correct?
Yes.
Judge, I'm gonna object to that statement because there's a difference between the service and the actual phone.
On page 1 of 29, Kathy texted him, I can see everything you're doing from your phone. Try calling Detective Lacey again or my mom. Is that correct?
Yes.
On page 14 of 29, the mom again says, your phone service is being turned off. Correct?
Yes.
On page 5 of 29, the mom texts her son, closing your BOA account. I don't remember if it said BOA or Bank of America. but-
BOA.
Okay. Indicating that she had joint custody or joint control of his account since he was a minor, correct?
Or act.
All right. So chat night, for those of you in the chat who've watched a bunch of law or lawyers, you can already see what is happening. This is called laying a substantial foundation. It feels awkward, right? You're going, why are we having these weird text messages that have nothing to do with the murder? Because he's trying to establish that the minor, the individual at issue who's being on the receiving end of these text messages, trying to establish that this person knows and is aware that their parent has control, access to, and visual dominion over, like can see certain things that this person is doing on their device. So the lawyer is and kind of doing it pretty directly, trying to establish that this child did not have an expectation of privacy in these communications. So I imagine this was the argument in several pretrial motions because there's no way this is the first time this is coming up. So the defense lawyer is probably aware this is going to be coming up, but now you're wondering, or I'm wondering, what's on this phone? What is it he's trying to establish?
Access to it.
Or what?
Or access to it. Yes.
Access to it? Okay. So that's another indication of something she had access to besides his phone?
Yes.
Page, I don't remember if I just said this, but page 14 of 29, your phone service is being turned off.
Yes.
Another statement
She
made.
said that multiple times.
Okay. Page 16 of 29, I'm still tracking you and your location, Collin. If I don't see your dot moving on a map towards home, and then whatever else you said,
Yes.
indicating that she's able to track him through the phone that she so graciously provided.
Yes.
17 of 29, you are reading each message I send. I keep seeing read next to each text I send. I'm shutting your service off.
Yes.
Page 18 of 29, I'm looking at your phone records, correct?
Yes.
Page 22 of 29, your call records with AT&T, you didn't even attempt to call Monique.
Yes.
And then is it a fair statement that Kathy attaches att.com screenshot of the records/phone calls for September 6th through September 8th of 2024 that the defendant was either making or not making?
I do remember seeing that. Yes.
Page 24 of 29, continuing with the text message conversation between the mom and the defendant. And you are at her house on Wi-Fi because your service is disconnected. Do you remember that?
Yes.
Page 23 of the Cellbrite report from the conversation between now Kathy and Susan Detman, her mother. Do you recall Kathy saying, Collin's phone will not be turned back on given that he lost his phone privilege when he hung up on me?
Yes.
Coming in the home stretch. Page 29 to 30, the same Cellbrite report. Do you recall mom sending Susan Detman screenshots of the defendant playing video games, kidnapping and killing people?
Yes.
The mom was monitoring what the defendant was doing in various aspects of his life.
Right.
And is it a fair statement? Didn't she also text the defendant, I can see what you're doing playing the video games?
Yes. She said it on the Ring camera as well.
Okay, so that's captured there as well?
Yes.
During your investigation and your interview of Robert Willantis on page 7 of 16 on one of the two interviews, Robert Wallant just told you Kathy did get Collin a phone. Do you remember that?
Yes.
Page 3 of Amanda Friends' 6-page report. She annotated.
You can hear the lawyer, like these pauses. The lawyer is basically saying, "Do I have enough?" He's kind of, well, he's thinking in his head. He's going, "Do I have enough? Do I have enough? Do I have enough at this point to get foundation to seek the introduction? Am I there yet?" And while the spinning wheel is occurring, it's the first instance this evening, which sucks because why not? While that's doing that, we're going to go ahead and do this. People were asking in the chat, who is Recovery Addict? Recovery Addict is this lovely gentleman, Scott. And Scott live streams trials. That's what he does. It's what he loves to do. So please check out his channel.
Also told his dad that his mom took his phone away.
Yes.
Page 3 of 6 of Amanda Friends, former DCF CPI investigators noted or commented that mom took Collin's phone away.
Yeah.
Is it true that the mom would take away the defendant's cell phone and AirPods as punishment for being disrespectful to her?
It appeared that way, yeah.
And from your review of Deputy Alexander Sharp from the Charlotte County Sheriff's Office, who he actually testified today, page 4 of 6 in his report, he indicated that the mom told Deputy Sharp she was telling defendant she will be making changes to his phone so that he will only be able to make phone calls and send/receive texts.
Yes.
Is there any other information or evidence that you have to show about the inquiry of that the mom provided the defendant his cell phone and the defendant was aware of the monitoring that pertains to, obviously the whole relevance of this is the defendant sending Jeffrey Rapkin the text about giving his mom the old knife to the neck from behind routine if she comes up with a gun or something like that.
Right. Just everything we've gone over.
Okay. Judge, I have nothing further for the proffer.
Detective Peters,
Let's start with the photo of the phone that appears to be the defendant's phone because it's an iPhone in a black case, right?
Yes.
But you didn't look at a serial number. That's not in the picture, right?
Yeah,
That
through the
Kathy-
photograph? No, ma'am.
Right. And there's no other distinguishing marks that indicate that it is the same phone that you collected later that belonged to Collin.
Other than it's very similar in size and the case.
You know how many of those kinds of phones have been sold?
Countless.
Yeah. Okay. So you also mentioned that the phone was obviously open when somebody took a picture of it.
Yes.
But you don't know how it got open, do you?
No, ma'am.
You don't know if Collin was asleep and mom crept in and took the phone from his room to take that picture,
No,
right?
ma'am. No, ma'am.
And you don't know if it was password.
Oh, you know, working at this point in time would be interesting.
Protected, but she somehow figured out his password against his wishes.
I don't know that. No.
It was not me that is in the courtroom.
When Kathy texted all these things on September 7th and September 8th about cutting Collin's cell phone service off, she was referring to the AT&T service, correct? At least so far as you know.
Yes, yeah, I would assume, yes.
And Mr. Levine has pointed out throughout the trial that minors cannot open an AT&T account on their own. Are you aware that that's true or not?
From my understanding and experience, yes.
Okay. But does Kathy opening an account for Collin prove that she had allowed access to every personal thing on the phone?
I don't know the circumstances in that household. I can tell you I have the same service with my children, and I do have access to all of their stuff.
Right. And you can agree that some families are more privacy oriented and some are not, right?
I don't know. Based on age, I would say no.
Of course, the detective's going to say that.
Do you know of any families whose parents don't go through their kids' text messages?
No.
Really?
Yes,
Yeah,
ma'am.
I'm going to testify
Wow.
right now that I know.
Wow. What? Do you know any family whose parents don't go through their kids' text messages? No. I know a few. And on what basis are we talking about? Wow. But of course, law enforcement, that he's going to do that. It's expected. That's something.
Never went through my son's text messages. At any rate, you said that the photo of the
No, I didn't want to do that.
actually, never mind about that. The text message from Kathy saying, "Give me the phone and MacBook that I bought for your education back." You have no idea where the funds for those things came from, do you?
No.
You're aware that Collin had a trust as a result of the probate from Oklahoma, right?
I am aware, yes.
And that was the source of almost everything that Kathy provided for him of substance.
I don't know that.
Okay. You saw texts between Kathy and Susan regarding getting Shelley, the lawyer in Oklahoma, to
Correct.
send money to an
Correct.
account to pay for things, right?
Yes.
Right. Including for the computer that she was supposedly going to buy. They were talking about how much it costed and that they needed to get the money from Shelley.
Yes, ma'am.
We're going to go to 1.25. We're going to 1.5. They're speaking deliberately.
So for all you know, that phone was bought with money from Collin's personal trust.
I can't testify to that because I don't know how it was purchased.
And you're aware that Kathy made things up all the time.
Sure.
Yeah,
Yes,
including from the text messages around the same date and time that you were just discussing.
Yes, ma'am.
I don't have any other questions.
Yes, just so I can read the text messages which Your Honor has seen at the.
Now we're going to get the text. Now we're going to get the text message. Now we're going to see why they want it in. TAC pay. I didn't miss this part. That's the judge doesn't. They're not going to rule on that. It's a little aside here. The jury's not there. This is a proffer. So I get it. She's not testifying in that capacity. She's just basically saying, wow, really? Well, I've never done it. The judge is allowed to rely on their common sense. So it doesn't sway the record one way or the other. So now we get the text message. What are they trying to get in?
Prior hearing into the record, it's very short. And for the record, it will be, if Your Honor rules that. What's that?
You're talking about the actual text from Collin and Mr. Rafkin?
Allegedly.
Yes, Your Honor. I just
I don't
want
need to hear those for purposes of the proffer.
Okay.
The proffer was to determine this preliminary issue.
Okay.
But Ms. Thornhill, it occurs to me in this hearing, we're focusing a lot on who pays for the phone or what are the source of the funds for the phone. The real question, the basic question is.
Okay, let me give you guys a bit of background before he gets to it. The text messages that are at issue. What is it that we're talking about? Why are we having this debate over, the phone? Here's why. The communications that they're trying to introduce are communications between Collin Griffith and his attorney that are communicating via text message. And they're trying to get Collin's statements that he is making to his attorney into evidence because they're saying they're admissions against his own interest. Now, if anyone's little red flags are going up of going, aren't communication with attorneys privileged? Yes, but. And there's a lot of buts. There's a lot of things that could be a but that could cause privilege to be invaded or privilege to be waived, depending on the certain circumstances. You guys have seen this argument all the time. So the state is trying to introduce the text messages. They are text messages between a minor and his attorney. Question is, does mom, whose phone these messages are on, so it's more, well, it's more complicated than that. They're trying to introduce text messages that mom has on her phone. So mom has screenshots or pictures that she took from her phone of Collin's phone, where Collin has communications with his lawyer. So you've got one phone. So if this little brick is a phone, if this is Collin's phone, and this is mom's phone, mom is holding her phone up and taking a picture of the messages on Collin's phone, messages that Collin has with his lawyer. And the state's argument is going to be that Collin, a minor, does not have ownership of the phone. Mom does. Mom owns the phone and has a right to the materials that are on the phone. Mom, being the parent and having that supervisor role, has the right and the entitlement to see those communications. Parents have the right to seize the cell phones belonging to their children. They have the right to see those things, those communications that are on there, especially if the parent is the one that purchased the phone. Minor children, technically speaking, don't have proprietary ownership rights. They don't have the ability to own certain belongings or things, right? So when a kid says, "These are my clothes, I'm taking them," technically, no, they're not. You take them by my grace. There's a lot of grace that gets extended, but that's the issue. Is, does the privilege remain intact despite the fact that the person who is essentially giving those communications over is both victim in this case and also the parent who has a right to have access to those communications? So that's the question the judge is presented with. Let me tell you how I would have argued this. Because when I came into this, the question was just asked me and I didn't see any of the argument. So I still haven't seen the argument. I don't know how they're going to argue it, but here's how I'm going to argue it. Here's how I would see it. You start from the premise that the attorney-client privilege is inviolate, right? The attorney-client privilege is protected. And the question becomes, does the client, in that instance, when they are communicating, does the client have the reasonable expectation of privacy in the communications with their attorney? And the presumption is that, yes, the client has the reasonable expectation of privacy in the communication with that attorney. So in order for that to be abrogated, the client would have to knowingly make a waiver of that privilege. Then people ask the question of, but what about the fact that the phone is owned by the parent? Yeah, the phone is owned by the parent. And the parent has the right to see what's on the phone. I mean, at the end of the day, at the end of the day, the lawyer that was communicating with a minor via text message shouldn't be doing that, because the lawyer should know better. The lawyer should know that their communications are not, technically speaking, between just attorney and client, but are between attorney and client being supervised by a third party or possibly being supervised by a third party. So you start with the understanding that the client has this expectation of privacy and confidentiality, and irrespective of the lawyer having done something that might subject that to outside overhearing or being picked up by a third party, the lawyer cannot waive the privilege that exists in the client's possession. So the client is the one who owns the privilege. The lawyer can't waive it. So if the lawyer makes an inadvertent screw up and all of a sudden communications are out there, it doesn't mean that those communications are not privileged anymore. You might see them, but you might not be able to use them against the other person. So that's the beginning part of this. And all of the arguments about the parent's access to the phone are interesting. They're very curious. But I think that the premise needs to go back to, when you have the client as a minor and the obligation exists as between the minor and the lawyer, that just because someone else has a statutory right or a legal right to see and oversee those communications does not waive the privilege that exists between the minor and the lawyer. If I, in a case, represent a minor child, I might have a contract, meaning the parent might be responsible for my attorney's fees, but my ethical duties exist with regard to that child, that minor. And I don't care if their parents try to browbeat me, yell at me, scream at me, or do whatever they want to do. I don't tell them the substance of my communications with that client unless the client expressly authorizes me and waives privilege and tells me to do that. So that's how I would have argued it. But one, it feels a little bit shitty for the state to be coming in and saying, we're going to argue this waiver, but I can also see why the state wants to do it because the text message communications, the substance of them are pretty damning. So let's see how they argue it. Let's see how they argue it in this instance, okay?
Is whether your client knew or should have known under these circumstances that what was in his phone would stay in his phone
So,
and would not be accessible to anyone. And what I'm looking at here is what appears to be, you know, the Griffith household looked like a surveillance state to me, and she was definitely surveilling everything he did, not just actually, but constantly on his back about what he's doing, what he's not doing. A parent has a right, even if the object is purchased by the child and owned by the child, stolen by the child, whatever it is by the child, to examine those items. A child doesn't have that kind of right to privacy.
Long crime, what are we zooming in on? Are we looking at the paisley tie? I mean, I'm a fan of the paisley tie. Why are we zooming in? Okay, I know you guys have a lot of questions. I will try to catch the questions. I will, because I know there's going to be a lot surrounding this, and it's one where we need the answer. I'm happy to answer them because there's a lot of questions that people were asking about this topic. And I even told in RA's chat, like, you guys, if you have questions, save them because this is something important. And honestly, we run into this a lot in domestic relations litigation because we're dealing a lot with children, custody disputes involving children, allegations by children as to a different parent. So we run into these issues all the time. And I was nervous because you don't run into this a whole lot in criminal cases. So I didn't know how it was going to be argued and whether the judge, who's not a domestic relations background judge, whether they would pick up on this stuff really quickly.
The child purchased by the child and owned by the child, stolen by the child, whatever it is by the child, to examine those items. A child doesn't have that kind of right to privacy. The child has a right to confidential communications with his lawyer.
right.
But under these circumstances, could I actually say, even if she hacked into his phone, I mean, knowing what he knows about his mother, that he had no reason to think she might go snooping in his phone, especially given the animosity is not the right word, but the tumultuous relationship that he had with her and the heavy hand that she had on his shoulder.
Judge, I don't think there's been any proof one way or the other. And the burden is on the state to overcome the attorney-client privilege, which is presumed. And while I agree, ring cameras in every room, there's still nothing other than these text messages from months later that are not between lawyers and clients saying, I'm watching what you're doing. And then after she said that, I don't remember if it was this time or another time, he blocked her to prevent her from looking. So that to me says that, I thought I presented it at the hearing.
Can you block it? Can you really block your parent? They can just take your phone. I mean,
Except if he's with.
what legal significance is a child blocking their parent when
I
it
don't
comes to the parent's right to inspect the contents of their child's possessions?
But and I don't even concede that there is a right to inspect private communications.
A parent,
Does that?
you don't think? I know you've chosen that route. I might be somewhere in the middle because I do think it's important to let your child have some privacy, but it's also important to know what your child is doing. But the bottom line is, what matters is what the law says. Are you telling me that the law affords a child some right against unreasonable search and seizure by their parent? You just leave attorney-client privilege aside. But I come home with some object that they didn't provide to me. They don't have a right to come in my room, look at it, see what it is, open it up, read it if there's something inside.
Well, Judge, I think that cell phones are innately different. And I don't have the case cites to all of the Supreme Court decisions talking about how uniquely private cell phones are.
Children's cell phones, you
Children
have
have a right to privacy.
from their parents?
Yes,
Show me
I
the
believe they
case.
do. I don't have one right now.
Whoa. That's that's taking a little too far. see where I started with the argument? See where this one started? Not in Virginia. They don't. No. It happens, especially on cell phones. It happens all the damn time. All the time. Yeah, that's pretty bold. I absolutely have the right as a parent. As a parent, you absolutely have the right in Virginia. You absolutely have the right to go and access that child's phone and be like, nope, I'm looking at it, every single thing.
Oh, yeah, okay. Mr. Hendry is dead on, and because he's practiced family law and I haven't, but even in family law cases and custody cases, sometimes parents are actually explicitly banned from looking at communications between their own child and the other parent.
Whoa. No, honey. No. I'm sorry. I didn't mean to be derogatory in that remark, but no. The parent can be ordered not to look at the communications between the other parent. And this is not that case. Oh, wow.
Mr. Hendry, I think, has to do more. I mean, at that point, a court has intervened because there's an issue that needs to be resolved regarding the best interest of the child. And those orders are typically not put in place unless you have parents who are interfering with the other parent's time sharing and rights to the child. So that's not so much to protect the child per se. It's to protect the relationship between that child and that parent, to prevent the other parent from interfering. That I don't think that's the same.
But Judge, isn't the relationship between a client and their attorney sacrosanct?
That's the second question. The first question, I mean, it's analogous to talking at the restaurant to your lawyer at a volume where someone else can hear. You knew or should have known someone else would hear that. It's today's version of that. If you're texting under circumstances where you knew or should have known, someone else is going to read that.
And that's where I think we differ. I don't think that Collin knew or should have known his mom would be reading messages between him and his lawyer.
I think that has absolutely been shown in this case that is exactly the type of person that she is. But you're telling me there's a case that says a child just blanket has this right to privacy as against their parent.
Not a blanket right, Judge. We're talking about very specific circumstances where she is the alleged victim in the case. And his lawyer was hired by his grandmother to represent him in a case against his mother. So even if she is someone who looks at his phone now and then, Collin had every right to expect that the communications that were privileged between him and the lawyer that is representing him against his mother, that those would be protected. And I don't know how much more simply I can say it. I think we're making a mockery of the attorney-client privilege if you allow this in, but I understand if that's your ruling. I don't think the state has established the ownership and control to the extent that she could invade, and he should expect that she could invade his.
Well, I'm sort of receding from that because it's occurring to me during this hearing that I think parents have those rights as against their child, even if it's not their property.
Oh, no. You went too far. You went too far. And now the judge is going against. No, you had the judge. You had him. And then you went too far. You tried to make it absolute. And the judge says, we're not doing the absolute thing. Now the judge is actually leaning the other way. So this is somebody who's made the argument too strong and is now alienating the judge who was kind of on his side there for a second. So that's
So that's like saying.
But that's a double-edged sword. I mean, you have to take this in the context in which it's arisen, which is he lived in a surveillance state with his mother.
Therefore, he doesn't get to have.
No, therefore he gets to walk down the block, take a jog, call his lawyer, or she can't hear it. That's what I'm saying.
Okay, well, we obviously disagree. I don't think this is the same as speaking in a loud voice in a public restaurant. I think that there was an expectation of privacy and privilege that the state has not overcome, but I don't think there's much of an argument to be made about it. Sorry.
Under the circumstances where we're operating, where he has no right to make a phone call within his home, but his mother also controls all of his assets and all of his belongings. How is he? I mean, we can set the hypothetical where he goes on a jog and makes a call, but if we're also conceding that mother has the access to turn off his account, how does he ever get a confidential communication? He's a child. He's stuck inside of his home with his mother controlling every aspect of that life. And then we're to say, well, anything he does inside that home cannot be confidential because he's in the home and he knows that it can't be confidential. Then we just become, it's a circle where we're never allowing Mr. Griffith any privacy.
That's the better argument.
And you would have to rely on his mother to take him to the office. Of Mr. Braun.
Wait, are we gonna let?
You could make a call in very limited circumstances. She had a ring camera in his room, which would be an invasion of
I
privacy.
agree.
but
Wait, are we doing? Come on, one horse, one rider, Judge. You're gonna let him tag team this? Other lawyer came in with a better argument.
I didn't realize that there was a ring camera in his room because I haven't gotten any footage from that. I thought we just had the kitchen and the living room. And the doorbell, sorry. It was clear from one of the body camera footage things that it says something you can tell she has a ring.
So, Mr. Levine, what I'm hearing is, I'm looking at this with too narrow of a view that what is a child to do in the circumstance where confidential communications with their lawyer either happen at the whim of the parent or not.
Judge, your decision, and obviously you make the decision, but where you were headed and what you were saying makes complete sense. I haven't said a word over here. The more the defense just keeps talking doesn't mean they're making more of a point. You shouldn't change where it appears you were going to, because you're supported by the law, you're supported by the facts, the proffer, the law, and what you've been saying, it justifies you allowing this to come in. But you're on the side of yourself. The first thing, he wasn't held as a prisoner. This guy went out all the time. He could go wherever he wanted to. He had his phone all the time. His mom, despite all these threats, very seldom did she ever cut his phone off or turn off his service. So he could do whatever he wanted to, whenever he wanted to. It's ironic because on the day when he ended up leaving the house, he was too lazy and disrespectful to do some simple chores because he wanted to go take his walk, which is exactly what he did. So he could have done that at any time. Another thing that I didn't mention, but I did mention at the hearing, is that so I think you're spot on. I think the evidence is spot on. My arguments and the evidence as presented would justify you allowing this in. If you do anything to the contrary, it would seem to go completely against what your gut instinct and the evidence has shown. Furthermore, one of the things I mentioned at the hearing was, it sounds like, the attorney's making the argument for the defendant, and of course she has the right and she should do that. But what I cited some of the case law and some of the propositions are, it's what was the defendant's intention and belief about if this is one of many things. This is just another thing that would support you allowing this in. But one of the things is, what is the individual's belief or thought process when they're having a conversation with an attorney? And you have to look at that through the individual, not some educated attorney who's been practicing law for decades and legal.
So he actually states the standard properly. It's subjective. It's, does the individual have a subjective belief that the communication is in fact confidential and privileged? It's subjective, it's one of the weird areas of law where the actual subjective knowledge or subjective understanding of the individual is what's respected and should be respected, honestly. But I don't know that this guy he's kind of making the argument for the other side. Like, you're better off on the argument of the ownership issue and the supervision issue and the knowledge and awareness. And why are you going down the subjective path? Because I think that favors the defendant.
Arguments and things that they're making and how their mind works as a seasoned attorney. But you have to look at it from the defendant, a 16-year-old who's talking about giving his mom the old knife to the neck from behind, which is how he killed her. When he's having a conversation with Jeffrey Rabbit, he's not sitting there thinking, "Oh my God, this is definitely going to be protected as the attorney-client privilege. No one's ever going to see that." He could care less about that. What he was thinking was getting information from his attorney and what he might do in the future, which was he would be happy when he had the chance to kill his mom and set it up, just like he did the same thing with his dad. But when he sent that text, I guarantee you, obviously the evidence supports this, and it's one of the considerations you should make, that Collin Griffith, the 16-year-old or 17-year-old, wasn't even considering the attorney-client privilege and wasn't thinking this will be protected. Nobody will see this. So that just goes to support what Your Honor should do, which is allow that to come in. There's nothing more humanly possible I can do.
Well, you're asking me to let it in under crime fraud exception.
No,
And we've talked about that.
No, I don't. No, I don't. You've already addressed that.
That is much less clear in this case.
That's not what I'm asking to let it in.
Yeah, it's not the crime fraud exception. That's the crime fraud exception is when you're actually engaging in the conduct to help perpetuate. Yeah, no, that's not this.
Because you've already made that ruling. That should say a long time ago.
I mean, it is. I cannot say to a level of that you've shown to the required level preliminarily that the crime fraud exception applies based on the context in which this lawyer was representing him and what appears to be eerie, and we've all recognized that appears to be a discussion about what can I do to protect myself.
No, and the way I'm thinking about it, you've already made that ruling last time, so I'm not arguing that today. But what I'm saying is you can and should consider it in terms of when he's making this text to his attorney. He's not thinking. Collin Griffith, the 16 or 17-year-old, is not thinking this will be protected by the attorney-client privilege. I feel safe in doing this. Whereas if Ms. Thornhill and Mr. Henry wrote the same text or a text like that, then they're adult, intelligent.
He doesn't have to be actively thinking that. But he doesn't have to be actively thinking this is a privileged communication. I'm safe in saying this. No, you don't have to actively be thinking I'm talking to my lawyer, therefore this is privileged.
educated minds would be thinking about this would be protected. But you have to look at it through the defendant's point of view. And the last thing on his mind was the attorney-client privilege.
Thornhill, Mr. Henry.
Under that logic, then we're providing less protection to a child for attorney-client privilege because they're less sophisticated and less smart than an adult. That goes contrary to the law.
All right, dude comes in and smacks it. That was awesome. Why didn't he make the argument from the beginning? Why didn't he make the argument from the beginning? Because that is going to win a judge over right there. We're going to repeat it because he just came in and delivered a freaking haymaker. He's just stands up, first line. Great way of coming back at this. Oh, what a great response.
I look at it through the defendant's point of view. And the last thing on his mind was the attorney-client privilege.
Thornhill, Mr. Henry.
Under that logic, then we're providing less protection to a child for attorney-client privilege because they're less sophisticated and less smart than an adult. That goes contrary to the law. That goes contrary to how we treat children in this justice system. We give them more protection and we give them more leeway. To say that they're not sophisticated enough for an attorney-client privilege is wrong.
I'm not persuaded by that, but I mean, I think there's probably a lot of adults that's not what goes through their mind when they're talking to their lawyer. And typically lawyers will tell their clients, what you tell me is confidential. But Mr. Levine, all right, we're going to take 5 minutes.
All right.
Smart judge. I like this. I like the judge. I like the judge. The judge he's being very thoughtful here. And I like the fact that he comes in. I personally like a hot bench, which is when the judge is asking a whole lot of questions to the lawyer. I like that because I think that you get to the better arguments that way. Lawyers are inherently adversarial creatures. At least some are. Let me give an example. Example. I had an argument case recently that resulted in a 26-page opinion letter that was written in Fairfax. But I had a case that was being argued, and we had a very limited issue on a discovery issue that brought up a bunch of evidentiary questions similar to this, privilege, but it was privilege when it related to medical records and information. And one of the factors the court's required to consider when they're considering and making a determination on custody and visitation is actually the medical history, the physical, mental, oh my God. Then existing physical and mental health of the both the parents and the children, right? So the court is required to consider these things, which usually provides an exception to a lot of the privilege arguments. But in this particular case, there was a very unique set of facts, and we ended up scheduling a hearing, and it was scheduled for a 3-hour argument on a motion to compel for discovery purposes. That is unheard of. But we had a 3-hour hearing that was set aside, and the judge we end up in front of is one of these. I had an opinion of him going into it, and having finished that hearing, my opinion of him just changed in a very, very good way. The entire hearing ended up being a theoretical debate, or a debate on how the privilege should exist, why it should exist, and statutory interpretation. It was one of the most fun experiences I ever had in court. It was 3 hours of 2 lawyers with a hot bench, a judge that's asking a million questions, and we're arguing. And sometimes it takes being challenged in your understanding to come up with a better argument. You think your argument's great until you get hit in the face with an argument that's supposed to combat that. And then you got to think around it. You have to figure out an answer to a question you might not have thought before. So you end up getting a whole lot more out of the equation. So I like when judges engage in this level of inquiry, because you saw it here. You saw how the argument develops, and you saw how little failures in the argument start to show up, and how the lawyers combat them and refute them. And I think the dude attorney for the defendant just came in with a great response, and it kind of caused the judge significant pause. The judge is going, I need a minute or two. So let's see. I think the judge goes immediately and takes it under advisement. Theologically. Yeah, that was funny. H Scorpio, JD. Yeah. That was a slip of the tongue.
You may be seated. losing my voice, so just a moment. All right, we're back on the record. Mr. Griffith is present with both of his lawyers. Mr. Levine is here for the state. There's a bigger question here.
Guys, if you have a question on this topic, and if you have a question on this topic, if you just write the word question, don't do all caps, but write the word question, and then ask the question on this topic, and I'll try to star as many of those as I can, and go over some of the ones that I think are more important. So, yeah.
That I don't know if there's any law on that occurs to me based on the arguments made by defense, aside from the more specific question of what the defendant knew or should have known. And the question in my mind is, does a parent, in the context of the attorney-client privilege, or just the attorney-client relationship of their child and the child's lawyer, have some obligation to facilitate attorney-client privileged communications? Meaning, yes, let's just assume that he had some
Interesting. Wow. I like you, Judge. Wow. Okay. I'm with you. So, as the adult in the room, as the parent and custodian of the minor child who understands and is charged with understanding, like you're an adult, that there is in some capacity an attorney-client relationship between your child and the attorney, do you then have a duty to kind of protect that? I'll take that and actually make what I think is a stronger argument. Not that you have a duty to protect that, but can they invade the privilege through you, who as a parent are aware that that privilege would otherwise exist? Huh. I like this argument. This is good.
expectation of privacy. Well, strike that. You have said, how is he supposed to communicate with his lawyer if mom can take the phone away? I guess my question to you is, does she have to facilitate it? Is that part of my analysis, that children should have a right to use property that their parents would otherwise have every right in the world? I mean, they could bring a locked chest home and the parent could cut the lock off if you ask me to see what's inside.
If the lawyer's in there, they're trying to get you.
That's different. Once that relationship has commenced or is in action, the lawyer can prevent that.
Judge, 35
But-
pages of text messages with a defendant, no problem communicating. He didn't need any help from anyone over many, many months, kind of proving that he had no problem getting to talk to his attorney or seeing his attorney. And Susan would have taken him there.
But what I'm
That's not helping your argument, Mr. Prosecutor. The fact that there are 36 pages does not help your argument. That actually goes to support the argument that he has an understanding these communications with his lawyer are protected. That's a shoot yourself in the foot argument.
I think you're missing my question. The communication we're talking about here occurred on a telephone. And so, is that what you're saying, Ms. Thornhill, that I want to get this right? And you're telling me children should be allowed to talk to their lawyers on their phones without having been found to imputed knowledge that their parents can get in there and see what they're saying. You're asking me to rule that way.
Yes.
And would that be contrary to the case law that we discussed at the last hearing and what the court is supposed to analyze in terms of what we were discussing about?
No one showed me a case about a cell phone and a parent's right to look in there even when and to use otherwise confidential communications. What would be a confidential communication if you were an adult?
No, but as it pertains to the defendant having no right to, no thought process that would even be confidential. And the analogy that Your Honor was talking a little bit about today, but we talked much more in depth about at the hearing, about if you send an email on a company computer, even if it has to do with lawyer-client privilege, and I cited a case, I don't remember the case, but I cited a
What's
case.
different is that person is an adult and has other means of communicating. This person's means of communicating with his lawyer was a cell phone.
He wasn't locked in a cage, Judge. He was at Susan Deckman's house all the time. He was using that cell phone as much as he wanted. His mom made a million threats, but never followed through basically on any of them. He's running around enjoying doing his walks. He was not held captive. He had almost like an adult. He could do whatever he wanted to. He had a driver's license. Susan Deckman would
Not
take
when
him.
he said that.
All right, fair enough. I didn't remember that. Susan Detman could take it anywhere. All, like what I was saying about the 35 pages of text messages, time-wise, like he had his phone and was using it anytime he wanted to. So it wasn't like he didn't have the opportunity. And I don't think that inquiry that Your Honor is talking about most recently changes it one way or another, unless there's some case, which none of us have seen a case that would support what the defense is arguing, case law-wise. So I think I understand that question might be interesting to Your Honor, but that shouldn't change your mind.
I disagree.
Well, I'm kind of thinking just the hypothetical circumstance. Suppose you have a child who has no other way to talk to their lawyer
But you're not going to worry about that. That's not the
other than
situation.
on a cell phone. Well, I think that's the starting point. What do you do in that situation? Does the parent have an obligation to provide a means of confidential communications with their lawyer?
And it's clear that question could be interesting, and it's definitely interesting to you, and I know you want to make the right decision, but that's not the situation that the defendant was in. And when you analyze that thought that you have, but under the defendant's situation, he's not in a situation like a hypothetical teenager might be.
I appreciate that you think I think certain things are interesting but irrelevant. It's more than interesting to me. It is, I think.
Yeah, that's a really dumb argument. That right there is going to get you in trouble with the judge every single time. Your Honor, I appreciate that you think this is interesting. No, I'm trying to make the right ruling in the case, and I would hope that you, Mr. Prosecutor, appreciate what I think is interesting, because what I think is interesting is likely to tend towards how I'm going to rule in this matter. So, and when you say it more than once, pivot, where's that? I think the pivot mean like of Ross and Chandler walking up the stairs, like pivot. Like you got to pivot around this, man. He's got you pinned down.
The fundamental starting point, and then we break it down from there. You can't answer the question though. Is that correct? Does a parent have an obligation? Does a parent have an obligation to facilitate, not this defendant, just as a matter of general principle, does a parent have an obligation to facilitate confidential communications between their child and their lawyer?
I haven't seen a case that says that, but
Can you tell me why they're arguing this point so hard? Because apparently the text message at issue are text from him to his lawyer talking about a wish or a desire to stab his mother in the back. So if they're allowed in, they're remarkably prejudicial because they talk about stated intention, motive, and his discussions.
by the same token, a parent could do or not do anything they want to. So if they want to be a bad parent and just not help their child in any way, shape, or form, there's no law that I'm aware of that would require a parent to get the child an attorney or to get the child to an attorney's office.
Missing
or
the
to help
point.
child in any way, shape, or form. As we
Missing
see
the
with a bunch
point.
of deadbeat parents who don't do anything. Not in this case, but just in general. A parent could sit back and be completely uninterested in their child's life, and that might not be against the law in the context that you're asking about if they have an obligation or a legal requirement.
He is just on a different planet. He's on a different planet. He's missing. He has no idea where he is right now. The judge has given you this hypothetical on the understanding that there exists an attorney-client relationship between your son and an attorney. Do you, as a parent, have a certain obligation to facilitate those communications that exist already? So there's already a relationship. You're not talking about deadbeat parenting. You're missing the hypothetical. The judge has boxed you into a question, and you have not answered it in any capacity.
To help their child have confidential talks with their attorney. So I would say no. I don't believe that there's a legal requirement. I certainly haven't seen a case law. And if there's some legal precedent to the contrary, I would learn something new if that was the case.
You've worked in juvenile.
I would learn something new if that was the case. That is not that. What are you talking? Are you a sore loser? Like, is this how he behaves when he loses arguments in other evidentiary matters? Because that's very whiny. First lawyer came up and whined, and the second lawyer came up. What is going on?
Never sat in juvenile, but do you know? I mean, I know the parents are, I don't want to say parties down there in criminal cases, but they're always called up to the podium. They're always asked questions, and I think the judge has some jurisdiction over them.
Well, it's the duty of the parents to make sure their child gets to court to deal with any criminal charges or delinquency
True.
charges. I don't know that any of our judges have ever punished a parent for not bringing their child to court. So I think there is an obligation of a parent to at least not impede. And
That's a better argument. At least not impede. You don't have to facilitate, but you can't impede. That's the one. You've got it. you hit the nail on the head. Now, can you drive it home?
Current with that, not impeding, should also be respecting the attorney-client privilege. Like I mentioned this at the hearing. If I'm meeting a client in the lobby of the public defender's office, a child, and I do that all the time, and a parent says, he's a minor, I've got to come in there with him. I explain to them that, no, you don't. Anything that I say to your client, to your child, and the child says to me is confidential and protected. The minute I let a third party into that, it waives the privilege. 99 times out of 100, the parent stays in the lobby, and then that 100th time, they say that I can't talk to your child. Sorry, I'm getting client and child mixed up. So I don't see how you can recognize that a child does have the attorney-client privilege, the protections that
Well,
exist.
that's interesting. In that 100th case, then you are recognizing some superior right of the parent to say,
No, I think she made a mistake there. That was stepping in it. You by allowing the parent in, you're not allowed to waive the client's privilege. You're not allowed to do that. The client can waive. You can't on their behalf. So I think that was a bad answer that she gave, because that puts the judge back in the position of kind of saying, well, by your last question or your last statement there, you're kind of acknowledging the parent has the ability to waive the privilege on behalf of the minor. And that's why I wouldn't have given that. It just, because I also don't think that, like I said, the lawyer can't waive that.
say no, you're not going to have confidential communications with my child because you say, I'm not going to talk to your
You know
child.
what I say, and it doesn't usually last longer than this one visit, I say, I can't talk with your child about the case in the way that I need to be effective with you present. I will
So
be
you're
happy.
you're not ceding to them. You're just
No.
saying, we're not going to do this here.
Yeah, and I also explained to them that I would be happy to answer the questions that I can answer after I've talked with them privately. I don't know how else other to say it than a child, well, case law does, I provided that case that talks about children have the attorney-client privilege. It's not superseded by their parents or somebody saying, we need to know where this child is right now, attorney, tell us where the child is.
I'm not disputing the child doesn't have the right or the privilege. So can you respond to Mr. Levine's suggestion that we're talking about Collin Griffith, who
Right,
had other means, had a car,
he didn't have a car at that point,
had a grandmother,
who lived in another county,
who he had a relationship with, a
Absolutely.
positive relationship.
absolutely.
And
But if he's got a lawyer who says, I am your lawyer, I work for you, anytime we talk, it's confidential, because the lawyer also doesn't know that Kathy maybe is intrusive and hacks accounts and things, and assures Collin,
well, I don't have that evidence of what the lawyer told him.
you don't have a lot of the evidence that Mr. Levine is talking about either, the claims he makes, and yet the privilege exists, and it's their burden to overcome the presumption of that privilege. I don't know how else to answer the question. If Mr. Levine is trying to say that Collin Griffith knew that this was not a privileged conversation, like he specifically did it knowing his mom was gonna look at it, I think that's absurd, and he hasn't established that.
I don't know that I would agree under the circumstances I've heard about this relationship that it's he would have no reason to think his mom wouldn't be snooping around. I don't know that I necessarily agree with that, but Mr. Henry, you've risen. Do you need to be heard?
Just a thought occurs that if we're dealing in these hypotheticals, if there was not this screenshot, if they have Collin's phone, Collin is a child, mother has access to this phone, they've done a cell write download of this phone, well, the message exists on the phone. He doesn't have confidential communications because somebody else has access to that device that may have just gotten it in without the mom. I mean,
I
that's.
think there are some cases that talk about that particular circumstance.
But I just.
I think it's what's in the mind of your client that's important in terms of whether there was he knew or should have known that another person would have access to it.
But if the access was the same, if mom hadn't actually taken that picture, but he knew that she had access to that phone, even if she hadn't taken that screenshot, would that still not be a confidential communication? Are we saying that anything that happens on those devices for children, they can never be confidential?
I like his argument.
Well, that's the question I'm asking.
I just don't think that. I think that's an unreasonable position to take in 2025, and the bulk of communication happens not face to face. There's nothing that supports the state's position I'm aware of that a phone cannot be confidential. The only thing that seems to be unique in this case is that somebody took a screenshot of a device and then sent it to a third party who, if we didn't have this warrant, I mean, it's not like these things, it's not like Ms. Bettman's on the stand right now testifying to this. We are using a detective who accessed this through a cell write download and a search warrant.
It wasn't, well, I think it's a side point, it wasn't a search warrant, it was a consent to search from Susan Devon herself, but be that here nor there.
But this is still, we are not in a situation where somebody was told something and then that person is on the stand saying, hey, I know this information. This is law enforcement gaining something from a search device. And I think that's different. And I think that this is still, to the extent that the child has, confidential communications, child has a right to privacy, but also there's parents' rights. It's all kind of murky here. I don't think that this communication has been breached from Collin's perspective. And I don't know that Susan or Kathy have the right to breach that on Collin's behalf without him doing it. And that's the ultimate issue here is, did Collin give up his right by putting this communication on his device? Because he didn't give it to anybody else. Somebody went through that.
Question I have is whether he knew or should have known that it wasn't going to be whether he knew or should have known others would have access to it, aka his mother.
That is one of the hugest, of course, inquiries, which we've been talking mostly about. The other thing I mentioned, which I know you said you were impressed by, but you still have to consider what was the person's intent when they sent the message from that person's mind. And I would ask yourself, I would ask you to ask yourself, when Collin Griffith sent that text message, was he thinking this is a confidential
Oh, shut up. Oh, come on.
I would submit to you the answer is no. I would submit to you that the other inquiry that we've been talking about, that the evidence that I've presented is evidence to support you ruling this admissible, Your Honor. If your answer is no to the question about whether Collin thought that was a confidential text when he sent it, not now after his damning evidence, and he knows that, oh, dang, it's going to be used against him, and his attorneys are obviously right to know that they don't want this in. It's not how they feel now or how it might look, but when 16-year-old Collin sent that text message, there's no reason that he would be thinking about the attorney-client privilege and that this is protected. So I think those two inquiries are paramount importance in your analysis.
It's interesting that Mr. Dean talks about how 16-year-old Collin couldn't have been smart enough to figure out that this is a privileged communication when they turn around and also argue that he's got this mock trial paperwork that's somehow informing him about how to make this whole grand plan to lure his mother to Auburndale. So I think that's ridiculous. I think you start with the presumption that it's a privileged communication. The state has not overcome its burden to establish that Collin did know or should have known that he was not making a confidential communication because his mother might be able to someday look at it.
All right, Mr. Levine, you're recalling this detective.
Yes.
Do we have to do this today?
No,
Because I want to
No, yeah.
make sure there's no cases on this issue and would ask a related issue, analogous issue, other than just the general proposition that a child has the right to the attorney-client privilege. I recognize that. But it is, as Mr. Henry said, murky when you're talking about parents' rights and children's rights. And just the basic reality, I think that kids know their parents can look in their phones.
Can, but should.
But the question is,
Or would a child say, okay, there are certain things that my parents should look at, like my internet activity, things like that, to make sure I'm not communicating with sex predators or buying drugs or things like that. But when
Well, there goes the monetization of the stream. Thank you, counselor.
and Kathy sees that it's between Collin and his lawyer, why is she looking at that anyway?
Because she realizes that he's going to kill her, and he's talking about how he's going to kill her.
I'm not sure. In any event, you know the issue that concerns me,
Yes.
which is a parent's right. I think it's sort of almost an absolute right of a parent to inspect their children's belongings
But once again,
and
the dad
the right of a child to communicate confidentially with their lawyer, and those two are intersecting here. And then what a reasonable child would understand under those circumstances.
The judge has hit the right concerns. At least we know the judge has hit the right concerns. So let me pull this down real quick because they come back to this and we're going to get a conclusion to this. Let me get some of these questions that were being asked and then we'll go through it. Oh, a reminder, Amber Natalia says, just ordered my cookies. Thank you. Yes, the link at the top of the chat is to purchase Girl Scout cookies. Now you have to hit delivery, but Girl Scout cookies being sold by the lovely, wonderful daughter of my wonderful paralegal. So that goes to support her. It goes to help her renew her Girl Scout membership next year. And also it's really cool to kind of, she can, when her mom's really proud of her that she sold all these cookies out of the back. So please do that. Catching up on something. So just because it says there's a whole lot to this case. The father's death was in Oklahoma. He was not charged or convicted with that and lived with his mom and grandmother for about a year. That's what I'm coming to understand. Just because Collin wanted to stay in the Baker Act holds, but his mom tried to shorten the stay. So his mom was picking him up. Okay. Lauren L. Does ownership matter? Prisoners don't own the phones, tablets they use, but legal communications are still privileged without an explicit third-party presence. No. And that's where I'm kind of at that place. For me, in my opinion, it doesn't really matter who owns the phone. The communication exists. Now, the question the judge has focused on is, did he have the reasonable expectation of privacy in those communications when he knew the parent could oversee those? And now you have two fundamental principles that are meeting each other head on. Parents have the right to see the things. Child has the right to privacy and communication with lawyers. And this, for me, is the tiebreaker. The tiebreaker has to be protect the privilege. It has to be. And that's why when that lawyer got up and said, well, judge, if you're ruling this way, you are now damaging privileged communication between minor children and their lawyers. And I think that that's the most solid argument that can be made. So that's where I went on that one. Joy W, is it like if a parent is present in the room with a kid and a lawyer? We talked about that a little bit, kind of, but not really. Is it not the same as doctors being able to withhold information? Kind of, without actual authorization or some statutory exception that would allow the doctor to turn it over. But attorney-client privilege is more ambiguous. It's not as express. There's a lot of facts that have to be debated on and brought to bear before you determine a privilege analysis. Random commenter question: a non-lawyer on a stream the other day in family law, do you see more divorces from watching spicy content or alcohol? Oh, this is a question you saw on another stream? I would say you probably see equal contribution, but realistically, I'm going to give you the answer of neither. It oftentimes goes, and I've had this discussion in the past, it comes back to communications. I'll bring this chat back up later. Let's see. June says, I grew up in the era of no cell phones. We had the phone in the living room and one hanging on the wall, no privacy. That's actually a good way of analyzing this. If you're the parent, actually, that's a good way of analyzing this. I actually would have shot back with the judge with that. Judge, let's take this back to the era of wall phones and cords. If this was a wall phone with a cord and the child is having a phone call with his lawyer, does the parent have some right to respect the fact that that phone call is occurring? I think the answer becomes clearer that way. Even though the parent has the absolute right to supervise and hear what's being said, does the parent have some obligation to respect the fact that communication taking place is between this child and the lawyer on a house phone in the home that the parent owns? That's a good way of analyzing it, I think. H. Scorpio, seeing lawyers help with the law theologically. Yeah, me too. Well, that was in reference to Joe and I. Yeah, it's fun. Red Cat, do lawyers have any type of obligation if their clients telling them they're going to harm someone? If they're just telling you that they are going to, the answer is no. The ethical rules say that if you know that that your client is going to harm somebody, then you have to do it. But I think the threshold, as I recall, the threshold is actual knowledge, not reasonable suspicion, but you actually have to know that this is going to happen. Like the person who's calling on his way to his ex-wife's house and says, I have this in my possession, I am doing this right now, that might trigger an obligation. And not even an obligation, that might trigger an exception that allows you to invade or abrogate privilege and make a communication to an outside party. Does the child's attorney have the responsibility to protect the client privilege? Yes, they do. They have an absolute responsibility to protect that privilege. Question, you mentioned before that the lawyer should have texted him. I said should not have texted him because he was a minor. What should they have used instead? Should they have just called, emailed, or communicated in person? And I think this is a good question too, because you can't really control when your client is communicating with you. You have the duty to tell them that the communications might be overseen by somebody else and to please and provide them with an alternative. And that alternative might be, if the kid has a school email address, maybe that way. I don't know. My recommendation is always in person or on the phone, like communicating verbally. Heather, surely the law would be looking at what the child knows about privilege. Would you know the privilege is not absolute? They kind of discussed that a little bit. I think that's not really the issue here. Is the issue the phone has incriminating evidence? Yes, that the text messages are rather incriminating. Heather says, can't they use the example of prison calls? They're recorded. You have no right to privacy on the calls unless you're talking to a lawyer. Then you have the right. That's more complicated because the state has to facilitate your communication with your lawyer because the state you have the absolute right to have a lawyer in those instances. Was he free to move out of his mother's place or not? My understanding is perhaps not. Holly Springer, doesn't an attorney have an obligation to notify proper authorities if they have reason to think their client will break the law? Absolutely not. Actually, the attorney has the opposite responsibility. The attorney is prohibited from communicating to law enforcement or any third parties about the substance of the communication with their client, with very, very, very limited exceptions. And I mean extremely limited exceptions. Let's see, the model rules of ethics. And that's because the attorney-client relationship is sacrosanct. You cannot invade that relationship because of the harm it does to the relationship that has to take place. Let me see, 1.6 is the rule on this point. Here is the rule, and this is the ABA rule. I don't know if Virginia is more stringent than this. Let me see. Let me see what ours is. Okay, Virginia's is more stringent than the ABA, but we'll take a look at the ABA rule real quick. So the ABA rule says the following. Lawyer shall not reveal information relating to representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation of the disclosure as permitted by paragraph B. So either informed consent, it's impliedly authorized to carry out representation, which means I've got to facilitate, I've got to do some action, communicate with colleagues, etc., or disclosure permitted by paragraph B. Paragraph B is the exception. This is ABA, which is probably the, it's going to offer the least protection. Not every state adopts the ABA rules, by the way. ABA is not the best when it comes to this. A lawyer may reveal information related to the representation of a client to the extent the lawyer reasonably believes necessary to prevent reasonably certain death or substantial bodily harm. So there's a reasonable certainty element there. To prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another, and in furtherance of which he has used or is using the lawyer's services. That's the crime fraud exception. Again, reasonably certain to result for financial harm, secure compliance with the rules, to comply with other law or court order. There are no laws in this instance that require you to divulge. And then to detect or resolve conflicts of interest. Now, the one that I am most familiar with is Virginia's, which is this one. So to the exception in Virginia, B, to the extent the lawyer reasonably believes necessary, the lawyer may reveal, comply with court order, information to establish claim or defense between the lawyer and client. So if the client sues you, such information which clearly establishes that the client has, so this is the crime fraud exception, in the course of representation perpetuated upon a third party of fraud related to the subject matter of the representation. So they're using your service to commit the fraud. Information is reasonably necessary to protect the client's interest in the event of representing a lawyer's death, disability, and incapacity. Not that case. Loss management assistance, statistical and bookkeeping, but then you're not, you have to actually protect the information. And then information is such information to prevent reasonably certain death or substantial bodily harm. So reasonable certainty, pretty damn high bar. And you can get in trouble. Like the ethical rules are there where, and again, it is permissive. It's not mandatory in any instance. Even the most stringent, if you are reasonably certain that the person's about to commit a harm, then you have permission to grant that. So, all right, so we come back to this. It was the next day. And I think we're going to get a resolution of this argument.
Children. And the exercise of his parental authority, a father has full access to similar holding, including
Sorry.
have
Mr. Hertel tells me, but before that, do either of you have any authority on the issue that we were discussing yesterday?
I do, Your Honor, I found a couple cases that seem quite illuminating. Your Honor, beginning with Tallman v. State, for the record, that's 120 Southern 3rd, 593. Tallman is spelled.
Come on. We can do this, folks. Please cooperate with me.
L-L-M-A-N. And on page 1 and 2, it mentions that a juvenile does not have the right to exclude a parent from access or control over his or her personal belongings. To hold as such would undermine the inherent authority of the parent. The second case, State v. SD.
Oh, baby. Let me close the other tab. Maybe that'll help.
The second case, State v. SD. And for the record, that is 758 Southern 2nd, 1253. Has a similar holding, including we hold that by virtue of his parental authority, the father's consent overrides the juvenile's objection. And then it talks about some of the rationale behind that, including a father has the responsibility and authority for the discipline, training, and
Wait a minute. What was that? Discipline training, but this control issue. But it's a control issue. Runkle will be along shortly. Yet another obligation.
some of the rationale behind that, including a father has the responsibility and authority for the discipline, training, and control of his children. And the exercise of his parental authority, a father has full access to the room set aside for his son for purposes of fulfilling his right and duty to control his son's social behavior and obtain obedience. When a parent basically, the parent can, in the first case, that can do as they see fit. The parent is exercising his or her parental authority and control over the unemancipated minor child. So I would submit that those two cases coincide with one of the court's inquiry regarding that subject matter, Your Honor, that would further support the finding that the text message, in conjunction with the attorney-client privilege law and argument and subject matter we discussed, that should be admissible.
That doesn't answer the question. Let's say that I agree with you that you have control. Let's say I agree with you that you have control. How does that deal with this?
And could you place their case names on the record yet?
Yes, sir.
You did?
Yes, you did.
Ms. Thornhill?
I have a response, as well as some cases, but I'll get to them if that's all right. First, I found no authority that talks about a parent's unlimited right to go through everything. I understand the cases that Mr. Levine cited in connection with the Fourth Amendment issue.
That's not the hill you want to die on, counsel. Don't start there. Stop trying to make the argument. Stop. That's not your winning argument. Go with the one that's going to win.
But of course, we're dealing with different issues slightly. So, parental rights assume that the parent is acting in the best interest of the child. I think that's the foundation. But the child also has rights vis-a-vis the parents, and those rights change over time with the age of the child, right? So a 2-year-old or a 4-year-old, obviously a parent has much more control and much more ability and authority to intervene in their child's behavior, their belongings. As the child gets older, the child's rights increase in relation to their parents. At any rate, even if you find that this mother, Kathy Griffith, had the right to snoop or right to go through Colin's cell phone. I still have arguments that relate to his right under the Fifth Amendment and his Sixth Amendment and his privilege to communicate privately with his attorney. So first, the privilege is only waived if at the time the communication was made, Collin intended it to be disclosed. And you mentioned, should he known or should have known that his mom might look. That's possible, but we still have to look at his intent and then what the mother did with her, I'm gonna call it snooping, looking. When we talk about people who are in jail, inmates, even though they have very restricted liberties and their right to privacy is severely curtailed, there is still a means by which they can communicate privately with their lawyer, right? So we have attorney booths at our jail that are private, are not monitored. So they have that ability to exercise their privilege. If an inmate makes a choice to call their attorney from the monitored line, say just call on the phone, they are warned at the outset. This is being recorded and monitored. Anything you say is not private. And if they choose to use that phone, then shame on them and the privilege is waived. But the important thing is that they have a feasible option to exercise their confidentiality privilege. But what choice did Collin have? We talked about this. Could he have made a phone call? As you pointed out, there are surveillance cameras everywhere in the house that could have picked it up. Could he have gone to his attorney's office? He didn't drive, he didn't have a license. Could he have called his grandmother in another county? Possibly, but is that reasonable? A child has restricted agency by virtue of them being a child. He didn't have any other feasible options. And I don't think a child should have to give up a privilege because they are a child, which is essentially what the state's wanting you to find, is that unless the child can somehow on their own, or if their parent's not willing to cooperate, can get to their attorney's office and go inside the office without their parent, then they can't exercise their privilege. It's like putting the burden on the child to do something extra to preserve a privilege that other people have easier access to, which seems unfair. But in addition to that, Judge, I may have been wrong in how I deal with parents who want to be present in privileged conversations. Because the case law indicates that due to parental authority, but that also includes duty, because parents are close advisors, and it's natural that a child would seek advice from a parent, and that a parent would want to be involved to some extent in making sure that their child is represented adequately, also to facilitate the communications, so driving the child to the office, providing the phone by which the child could call their attorney. There is a case that I found, nothing in Florida that's directly on point with this particular issue. It's Doe versus Town of Greenwich. It's 473 Federal Supplement 54. It's from the District of Connecticut from 2020. A brief rundown of the facts.
470.
District of Connecticut from 2020. A brief rundown of the facts. Two minors had an interaction where the female alleged that the male had attacked her, had sexually assaulted her. It's not a criminal case. The girl's family, on her behalf, sued the Town of Greenwich, saying that they had not provided adequate supervision and investigated the criminal case adequately. So that's kind of neither here nor there. At any rate, the suit was between the girl and her family and the town. The girl's family, and it's unclear how they got these emails, but they obtained emails between the boy, now he was a non-party, but the boy and his lawyer, and the boy and his headmaster from his school that discussed what he had discussed with his lawyer. All right, so the kid himself actually disclosed to a third person, his headmaster, communications between him and his lawyer.
Oh, so is the argument the kid can't make a knowing waiver because he's a minor?
And the federal district court held that even though the other side already had them, and even though the child had purposely, so very different than what we have here, purposely told somebody about those communications and shared them, that the attorney-client privilege still existed and that those communications were not admissible in court. So a couple things with this case. The court found, they talk about how minors are treated differently than adults out of the recognition that they do not always know, due to lack of maturity and moral experience, what it is they should be doing or not doing. And given the various protections afforded minors in the law, it seems particularly harsh to summarily find that Roe, the boy, waived his attorney-client privilege when he shared privileged communications with his headmaster. During the investigation, Roe, the boy, was 16 years old. There was an investigation into his behaviors that left him scared and anxious, and it's clear that he considered his headmaster to be a friend and source of guidance and support. It goes on to say that under the circumstances presented, the court concludes that Roe did not waive his attorney-client privilege by virtue of his disclosures to the headmaster. So it talks about the protection of children and their rights, given their unique positions as sort of subservient to adults in their life. I would argue that the headmaster is analogous to Kathy Griffith. It's not a completely on point analogy, but Collin communicating with his lawyer and knowing that his mom might find it doesn't excuse, and this is something that this case also discusses, doesn't excuse what the mom does with it later. And that's my second point. That's that, okay, so maybe you find she had an absolute right to look through his communications with his lawyer. Or maybe, as her duty as a parent, once she realized they were privileged communications, she has a duty to act in the best interest of the child and not go sharing those with other people. And certainly that shouldn't translate to, if she does make the bad decision to breach the attorney-client privilege, to allow it to be admissible in court of law against her child. She also was the alleged victim in that particular case. So she bears some responsibility in doing what's best for Collin. I think she violated that duty by sending it on. And even though the cat's out of the bag now, I don't think that her maybe having a right to go through clearly privileged communications gives the state the right to use that in this criminal case. She was parent has to act in the child's best interest, as I said. But even if you're engaging in some weighing of the rights and responsibilities and duties and the duty of a child to obey their parent, it doesn't wipe away the privilege that exists. I provided RLR 116 Southern 3rd 570 from the 3rd District Court of Appeal in 2013.
You have acted on that.
No, I gave it to you at the hearing.
Oh.
But I'll give it to you again. It basically talks about even if it would be in the best interest of the child to deem the privilege waived, in this case it was for the protection of the child, it still means you can't violate the attorney-client privilege. Additionally, under Florida statute section 90.5021C2, talks about that disclosures to third persons who are necessary to the communication between the defendant and the lawyer, or between the client and the lawyer, are not waived from the privilege. So if you accept the state's position that the mom had every right to do everything she wanted with her kid, but she is the only way or the sole way that can facilitate the communication between Collin and his lawyer, and she's the one who controls the phone, apparently.
Yeah, she owns the phone. Okay.
Right? Then even if she found the message rightfully, it still doesn't mean that it's waived. And she doesn't have the right to waive his privilege, even if she is in a position of authority over him. The privilege belongs to Collin. I'm almost done, I promise. Then we also, sort of as a logical argument or an overarching view, if you decide that Collin waived his attorney-client privilege by using a phone that his mother controlled and had the right to look into, if you take that to the the logical extension of it, then how is a kid ever supposed to communicate privately with their lawyer unless their parent can facilitate it, in which case then they would never have the right because their parent would be the third person that was involved, which I think completely vitiates the purpose of the attorney-client privilege and should not be a rule.
All right, so Thornhill, I had essentially come to a very similar conclusion as yours, agreeing with you. First of all, recognizing I believe the law is clear that a parent has the absolute right to determine what extent the child will have privacy in that relationship. But I agree with you that there's an overarching duty of the parent to act in the child's best interest. And when a child is facing legal jeopardy, that would, and that's recognized across divisions of court, dependency court, family court, criminal court, a parent has a duty to act in the best interest of their child. And that's probably, in fact, why that absolute right of surveillance exists, so that you know what your child.
This is the one of the key things I think it's important, and it might help actually resolve some of the questions in the chat right now. So, yes, we're having a conversation about a minor, right, and communications that are damning, and people are saying, but he's 17. Is he really a minor? He knows what he's doing. He's 17 years old. It doesn't matter. You don't get the communications. Let me put it this way. You don't have access and control over the phone if he's not a minor. If he's not a minor and he's instead an adult, that communication is privileged. Doesn't matter if you own the phone or not, because he has an expectation of privacy in the phone that he is accessing, the phone that he is password protected, regardless of who owns it. If he's an adult, you're not getting the communication. So it is only by nature of the fact that he is a minor and a parent has access and dominion over the phone that you even can see the communication, right? So there's your first premise. The parent has access and dominion over the phone. But on the other end of that coin, you also have the fact that he's a minor, and we afford additional protections to minors. Protections that are granted by the state and protections that are supposed to be upheld by the parents. So you take the good with the bad and you try to make it a wash. So I think this is the right ruling.
Is getting into or is being exposed to, so that you can make the decisions about guiding that child, providing the appropriate services, and so forth. So the right and the responsibility go hand in hand. And I think that's something that we fail to recognize across the number of rights that we have these days, that they come with responsibilities.
Thank you.
So I agree fundamentally that a parent, when it comes to an evidentiary privilege, meaning those secrets that they find in the locked box being what would otherwise be subject to a claim of privilege, that parent has a duty to act in the child's best interest with respect to those secrets, even when the parent is at odds with the child with respect to those secrets. Now, that's not to say I don't believe the parent cannot act on those secrets. For instance, call law enforcement, separate herself from the child, even initiate a Baker Act, file criminal charges. But what I have a hard time with is that once that child is sitting here in front of a judge and a jury, whether that circumstance could ever operate to waive the claim of privilege, when it is just the parent who it was exposed to. But Mr. Levine presented me this case, and I need you to tell me how it's different, because although it's a Fourth Amendment case, that evidence would have been suppressed. Otherwise, that evidence would have been suppressed if the parent did not have a right to consent to a waiver of an important constitutional right, which is to be free from unreasonable searches and seizures and have that evidence used against you in court. How is this different? Because in essence, it's sort of the same. And that's the law in Florida. A parent can consent to the search of a child's bedroom, and that had not even crossed my mind during our discussion. So what is the difference here? It's evidence being used against a child in court. One, it's okay. And one, you're saying, and I initially, through my thought process overnight, agree. But what do we do with that case?
I think that those situations are distinguishable because the government is acting, right? Your Fourth Amendment right is against the government from engaging in unreasonable searches and seizures. And when the government comes and says, I want to search your kid's room, the parent, as the parent with rights and responsibilities, and maybe not knowing what's in the room, because if the parent had snooped and known what was in the room, then they would have a duty to do with it what they thought was best for their child, right? But here we're dealing with a government actor intruding on a private place that the parent pays for, that the kid is has some duties towards the parent too. And the parent can say, all right, government, come into my house and search, right? That's very different than a mother who on her own has the duty to protect her child, the duty to act in the child's best interest, who goes looking through their private communications and then shares it with people, okay? It's another thing. Even if Collin knew his mom was gonna look at it, if she's facilitating the communications, that doesn't mean he intended it to be disclosed to everyone and be used against him. So I think that because the government wasn't acting at the time here, and mom took it upon herself to totally destroy his attorney-client privilege by sending it to Susan, and then Susan, maybe by accident or not knowing the implications, then turned her phone over to law enforcement. I think that's too many steps removed from a government actor coming to a home that the parent owns and controls and says, can we search your kid's room?
So what about the circumstance where the state issues an investigative subpoena to mom and says, tell me what's in that phone, and the mom willingly complies? How is that different? And says, yeah, his phone said he was going to stab me in the neck, to his lawyer.
I still think it would be privileged.
But how is it different? They're both essentially at their core evidentiary privileges. I mean, I think unreasonable search and seizure is broader and protects individuals' privacy as well, but it also is subject to the rule of exclusion if there is an unreasonable search and seizure. So at its core, it's an evidentiary issue.
We're also dealing with something a little bit different in that we're dealing with a privilege of confidentiality, which is different than living in your bedroom, right? So for instance, with the psychotherapy patient privilege, a parent can't waive that on behalf of their child, even if they know what happens in those therapy sessions, because it's the child's right to confidentiality. in certain things. And there are very few
So it's because
privileges.
the child doesn't own the bedroom, that it's different, is what you're saying?
No,
It's-
not
It's the
entirely.
parent's right to determine who has access to what they own.
No, the law doesn't provide a child an absolute privilege like it does in their bedroom, like it does between a lawyer and the child as a client. We have to start from that place, not the backpack he's carrying, the room he lives in, where a government actor is trying to find something. We're dealing with the privilege exists. Very few privileges exist that keep things completely confidential. This is one of them.
And so, Mr. Levine, you have a response to that, that consent to search a bedroom is different than consent to give up confidential attorney-client communications.
Yes, it's not, Your Honor. I mean, both are evidentiary issues at their core because ultimately the state is trying to use evidence, however it was obtained, and I submit that it was obtained lawfully. What Kathy did was not.
It's been personal to the client. And unless the court has been personal to the client. So exclusionary claim under the difference lies in the, anything else, Ms. Lauren?
No, sir, I
All right.
think you understand our position.
I think the difference lies in the fact that the law has said a parent can consent to the search of a bedroom of a child, and the child has no exclusionary claim under the Fourth Amendment for not consenting himself. When we're talking about the attorney-client privilege, I have not seen a case, and you have not presented one to me that says point blank a parent can give up a child's attorney-client communications to law enforcement. And that right has always been personal to the client. And unless the court decides otherwise, that it's personal to the individual, I don't think this case is analogous. And finding that a parent's absolute right to surveil their child serves as a tool for their responsibility to act in the best interest of the child, in this case, and under these circumstances, means that when it is just the parent who the child might have reason to believe will see what's in the phone, there could be circumstances where this wouldn't apply. If he knows that he's sharing communications in an environment that others are going to be aware of that don't have a duty to.
Example, he's the text to the lawyer is a group text. That's a good example. Like if he's texting a group text,
protect him. That's a different story. But even when a child's legal interests, a child in legal jeopardy, even when those interests are contrary to the parent's personal interests, that doesn't vitiate the parent's duty to act in that child's best interest. And I think we see that in court downstairs in dependency when the parent is the victim of a domestic violence incident, for instance, in juvenile court. The parent still has a duty under those circumstances.
Yep.
It doesn't vitiate that responsibility. So that being said, I do not find that in this case, even though Mr. Griffith knew or should have known his mom was going to look through his phone, that in and of itself, with respect to her and her alone, in any way would have waived the confidential nature of the communication. Again, finding that the state, while the actual communication itself was unusual, eerie, it was also apparently in the context of some discussion about self-defense, and there were no other facts elicited at the hearing, no other context provided where I could say.
all right, we got the ruling. Okay. So I know that some people are tired of that. I get it, guys. But here's the thing. That's really fascinating, a really fascinating area of law and something that actually comes up more often than you would think. And I think it's going to come up even more. So to the question I saw in the chat about whether this could set precedent or this could have any precedential value. No, trial court rulings don't really have any precedential value. I mean, if a trial court in a different jurisdiction sees what a trial court did, they can basically say, "Oh, I think that's persuasive to me," and that might sway how I'm going to decide here, but it doesn't control how I make the decision in my court or in my case. So it would have to go up on appeal. And let's face it, if there's not really a circumstance where this issue gets appealed up based on the fact the judge excluded it, I could see a judge making a different decision. I think the decision would be wrong. So, Patty P, the ruling was that the communications are still privileged. You're not getting them in. The judge basically said, even though the parent has dominion and control over the device and has the ability to access that ability to access that device also carries with it a certain responsibility that you're going to be acting in the best interest of the child, which actually means to be maintaining some of that privilege. So the judge basically said that he's not going to circumvent the privilege because it still existed, and the mom in some capacity had the ability to make sure that privilege was maintained and held sacred. So it's very fascinating to me because you don't see this come up a lot. You know, there's a question about, we got the ruling. Guys, he ruled. If you didn't think the subtext was clear enough, he ruled. It's not coming in. That was his explanation. I mean, literally, I'm looking at this, there's one more second of him talking before it goes to the seal. So he did grant that ruling, or he ruled, he excluded the text messages. So the question that ends up being brought up is, how far does this extend? I mean, this is communication from a child on a cell phone. Right now you have a bunch of, I think it could apply in other cases. I was very fascinated by it. And it brings up a very great question about privilege and what privilege is and whether privilege exists. And a lot of people have a misconception about privilege. People think that, you know, you have a duty to report certain things. We don't. Good question. What happens to privilege when a client needs an interpreter? That is one of those exceptions where you can reveal certain information in facilitating the lawyer-client relationship. So that is an exception, but the privilege still attaches to the person you reveal information to. So if that interpreter then goes out and starts saying anything, I can shut him down and make him stop. So let's catch up on some of the chats, make sure that we get everything, then we'll go to the next topic. A little bit of an oddball. Kind of interesting. I thought so. I get it. Honk Banana, no, creme brulee is just burnt pudding. Yeah, but it's good burnt pudding because the sugar is burnt. That's Seth. I prefer cheesecake, but I have had bad ones at restaurants, so chocolate cake is safer options. I think chocolate cake can be dry at restaurants. Azam, Rob loves seeing you and Peter on his podcast. Brings back memory of the first collaboration I watched. Recap of the Camille cross-examination with Amber. Yes, I had a great time with Peter. Peter has the channel, The Lawyer You Know. We discussed some of the attorney back and forth in the take care of my case, the conflict that exists right there. And I do understand there were additional filings in that. And that is just becoming more and more and more of a shit show. So not the prettiest circumstance, and I feel really bad for Maya in that case. Hey, Rab, there is troop 2 troops option where the cookies will be sent to the troops if you want to support Annalie, but don't need the cookies in your house. Yes, so the link at the top of the chat is for my paralegal's daughter who is selling Girl Scout cookies. And if you buy the Girl Scout cookies, then my paralegal does extra hard, really good work for me, which helps me in court. At least Charlene, fine art. Rob, please thank your assistant, paralegal. Finally got my Girl Scout cookies. I will absolutely pass that thank you along. Lauren Rose, I see Karen Reed on the docket. I sent you a Twitter DM last week of a video from my hometown of Cleveland, Ohio. Sort of funny, but semi-concerning. You'll see why it's relevant to Karen Reed. If you pull it up, keep it muted because of music. I can double check that, Lauren. I'll see if I can't find it. So I'll double check that. See if I can't find it. But warning, a lot of these DMs are, there's a whole lot of communication that I have not read. Oh, found it. I'll take a look at it. Thank you. Random commenter, we talked about this briefly. Realistically, a lot of divorce just comes from breakdown of communication. And I know that people say that's the bullshit answer. No, it's not really a bullshit answer. Everything. Affairs, addiction to alcohol, addiction to spicy videos. A lot of this stuff comes from the husband and wife having an inability to communicate and not making the effort anymore, or not understanding each other before they got married. I mean, you see everything. No person in any divorce is blameless, with very limited exceptions. So you see a lot of it. Random commenter, no idea if it interrupted getting here late. Sorry, no worries. Mispronounced name, I'm late to the party. Can you please sum up the first hour in 60 words or less? Chocolate, giant, piñata, Rob late to stream and talked about privilege. ADK divorce, shared cell plan, expectation of privacy. To some extent, yes. To some extent, no. So I always tell clients communicate via peer-to-peer apps that are encrypted end-to-end that don't show up as text message communications on cell phone bills. Or get a different phone. Sinbad 33, will this ruling set a precedent? Answered that question already. Not really, no. But it's could be persuasive. The arguments that are included in that would be argued again at different court levels. And you could have a judge making a different ruling. At least, Charlene, I did. Thank you very much. Sorry, it took me a while to get to it. Finally, Freed. With great effort and support, I made it to 41 today. It's a privilege to celebrate with you and your wonderful community. Rob, please don't ever underestimate the positivity you bring to the world. Finally, Freed, congratulations on 41. Cheers to you. I hope that you are having a wonderful beginning to your next year and that the past year was one for the books. Cheers. Happy birthday. Canonical Heat, thank you for gifting memberships. Jamie F. Very interesting. Thank you for covering. Thank you. Elf Liggins, glad you're back. It was rough without you and Ian. Thank you, Elf. I'm happy to be back. Just because. Thank you for covering this again, Rob. Maybe you could do a brief deep dive on the case after the verdict if you're so moved as well. From what I understand, that relationship, that family dynamic was not healthy in any capacity. There were ring cameras throughout the house, in the bedrooms, all over the place. There was language used that there was a lot of mental health concerns. I mean, that dynamic was something else. So you don't see that a lot. You see certain elements of that in various cases, but all in one, that's pretty wild. Zeph, it's already a year since we broke the Girl Scout cookie site. It is. AKA the cat lady. Did you see the Ruby Frank and Jody Hildebrand got sued? I did. I haven't been able to pull that lawsuit up. I know that Ian has it on his docket as well. Okay. Let me see. Why are people laughing? What did I say? Something silly? Lucy Wu. I ended the year laid off and started this year at my dream position with an amazing company. Cheers to you. Some things just work out the way they're supposed to. Thank you for helping me keep your head up. You have to keep your head up and keep your head moving forward, man. Some of the worst things in life happen for the best reasons. Doesn't feel like that in the moment. It doesn't feel like that in the days after and the weeks after, but I mean, some of the best things in my life come out of some of the hardest things I've gone through. Celestial Heather, wish could have met you and Runkle in Vegas next year. That's always the hope. I promise you, if I don't have things going on and if Ian's happy to have me, I'm happy to be there. I just happen to have actual court stuff that made it impossible for me to get there. Okay, so let's go ahead and get to our next topic. Let me see. The next topic is going to be a rather short one because it's going to be Sarah Boone. Sarah Boone is back. And when I say back, I mean back again. Sarah's back. Where's my material? Find it. Tell a friend. Sarah's back. Sarah's back. Sarah's back. Da, 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 da. And finding the material so I can enlarge it. Open. Sesame. Open, see, say me. Present screen. Yes, Sarah Boone is still a thing. Sarah Boone is still a thing because Sarah Boone still files stuff. Notice of inquiry. One, I've never heard of anything called a notice of inquiry, but it sounds very, very professional, right? Notice of inquiry. Comes now Sarah Boone, pro se, but not really, and files this notice of inquiry with the clerk of the circuit court in the above referenced case number, inquiring as to the status of appointment of appellate counsel. The last entry on the docket in this case shows that Joshua Adams, Esquire, was appointed to represent the defendant on December 18, 2024. However, she has not received any correspondence from him, and her application of indigence to be appointed an appellate attorney was not filed with this court until December 23, 2024. And Sarah's back. And would you expect anything otherwise? No. The answer is no, you would not. So at this point in time, I'm going, wait, what happened? Where is said lawyer? And what's going on with the docket? Because the way that she writes this is we don't have appellate counsel, but we should, because if the issue is that there needs to be an appeal filed, that appeal needed to have been filed. Here's the order that appointed appellate counsel. Oh, and there's the postage stamp from Ms. Boone to the clerk of the circuit court. So at this point in time, I was freaking out because I was like, wait a minute. Did the deadline for filing notice of appeal get missed? And then this doesn't make you feel much better when you see this being filed in the court record. January 29, 2025, 8:52 a.m. by the clerk of the circuit court criminal division. It says, as of January 29th, being 2 days ago, to Miss Sarah Boone, in response to your correspondence dated January 21st, the following applied. Other attorney Joshua Adams has been appointed to represent you for an appeal. However, at this time, no notice of appeal is on file. Well, that becomes a big problem, because this would be beyond the date an appeal could be noticed. Because I believe the conviction in this case, if I check the court record, let me double check the docket. The docket indicates the following. But again, it's kind of like, I agree, I'm kind of burying the lead here, because there was a notice of appeal. You can see it right there. Like, Madam Clerk, I see this. It's right here. It even has this cool little e-filing stamp on it that says it was filed on December 18th. So what's going on? Notice of appeal. Notice is hereby given the defendant, Sarah Boone Appeals, District Court of Appeal, 9th District of Florida, the judgment and sentence of the court. Everyone is notified. So James Jones was the one who noticed the appeal. So the notice of appeal was filed. Oh, maybe that's the confusion. But the notice of appeal is on file. Now, when I ended up pulling the docket has a really interesting entry here. I'll show you. And I mean, hell, I'm confused by this damn thing. So here's the docket. And you can see right here that you've got on December 3rd is the sentence, the amended sentence to correct your credit for time served is right there. Then you have the court minutes, December 3rd. Then you have her nasty grammar to the judge, 28 pages of how she was vilified and was terrible, and the judge was mean, bad. And then you have the amended sentence that's there, the order, and they have the order appointing counsel for the appellate counsel on December 18th. These are things they want reviewed, motions to reconsider, basically. Then there's the notice of appeal. But then there's this comment. Received by the clerk on January 31st, 2025. Will someone make that make sense, please? Because, I mean, we saw it. There's this really cool thing about e-filing, and when you e-file stuff, you know, it tells you He filed on December 18th. So the clerk ends up doing this, but the clerk says that we received it on January 31st, but you can see the filing date accurately reflects the December 18th. So the notice of appeal, the appeal itself and the timeliness of the appeal appears to have been preserved. But why did I bring this up? Why is this topic going to be a topic? Or not right now, not really. This poor appellate lawyer is in for the ride of his or her life. I believe his life is Joshua. Because here's the thing about appellate lawyers. Appellate lawyers, they deal with things in writing. They deal with trial transcripts. They deal with they don't have to deal with a client talking to them because all the words the client said are in a transcript that's already transcribed, and the Court of Appeals is limited in what they review by what was actually said at trial. However, the suggestion from this notice of inquiry is that Ms. Boone intends on being just as involved in her appeal as her trial, which is going to prove very interesting when they're trying to make arguments of legal error and Sarah Boone wants to vet the appellate arguments before they're being made. Holy crap. Can we all just take a moment of silence for this poor lawyer who now has to consult his client on what appellate issues are going to be argued and how they're going to be argued? Because one, appellate lawyers don't usually deal with clients in any capacity. And two, I can guarantee you appellate lawyers don't deal with clients like Sarah Boone. Because 99% of trial lawyers don't deal with clients like Sarah Boone. Holy crap. This is going to be some wild ride. And the only thing I wish is that we could somehow see how it transpires. Because just imagine being in the room trying to say, you want to argue back. I mean, trying to explain the concept of appellate law to Sarah Boone, who says I was a battered spouse, right? Try to explain that concept to her and then say, I cannot appeal and re-argue the facts. I can appeal and argue there was error made in allowing certain things to be presented or not presented, but you got to present your battered spouse defense. You got to present your doctor's testimony. I can make arguments as to what should or should not happen, but that's not going to fly for Sarah Boone. No chance is that going to fly. Oh my God, no chance. She is going to say, I want to re-argue this 9 times. The appellate court will understand. Do you think she's written a letter to the appellate court yet? No. Wait a minute. Can I look this up? So for those of curious, notices of appeals are filed in the trial court to notify the trial court to prepare the record and get it sent up to the appellate court. And then the appellate court receives the record after that at some point in time. But District Court of Appeal, 9th District, Florida. Let me see if they have electronic. District Court of Appeal, 9th District. Oh my gosh, this is going to be great. There's nothing at the appellate court yet? No, come on. But why not? Because you just know that something's going to show up there. Wait, 9th District. There's no 9th District. The 9th is encompassed in the 6th District. online docket, case information system. I trust you for making that. I trust you, but I also just want to see for myself because I'm remarkably curious. Role would be the how do I find you, my dear? Sarah Boone. Searchy search. No, nothing there. Damn. Because you know there's going to be letters. You just know it. In your heart, you know it. She's going to write letters to the Court of Appeals. Is someone going to give her the address? This is going to be a disaster. So I think this is going to be really fascinating. It's a really limited issue because there's really not a whole lot there. I haven't read the family law letters. If you guys want to send those to me, you can. But this appeal is turning out to be just as interesting as the trial itself, and you're about to get just as much correspondence in the appeal as you did during the trial. Because you know what? Why the hell not? Why the hell not? Okay. So, you guys want to talk about Karen Reed or you want to talk about some New York shit? Because I can tell you the New York shit, if there is a chance of Ian jumping in, you're going to want Ian to talk about the New York shit. So let's talk about Karen Reed. Before we do that, let's pull these down. Sandy, get the memberships. Thank you very much, Sandy. That's very kind of you. And look, Barney AB, guess who's back again? Sandy's back with some gifted memberships. Tell a friend, guess who's back? Guess who's back with gifted memberships? Thank you, Analytical Barney AB. Fear Dragon Rob, up where Owens is from, many defense lawyers are also appellate lawyers. Oh yeah, Northwest Florida has its own separate bar from the rest of Florida. I 100% believe it. Analytical Barney AB is returning the favor of gifted memberships, 10 gifted memberships, and then 10 more. Thank you very much for that. It's extremely kind. Okay. Here we go. Karen Reed. Let's see if we can find a stream that actually works, functions for this particular hearing. Mm-hmm. What do you want? Boston 25s. We want law. Keep doing it, but let's go with law and crime, shall we? Because they do. Make sure I've got the audio set before I share the screen. Make sure that we swoop to make sure we're going to Karen Reed. Swoop. All right. Judge Bev, we are back on the bench hearing various motions today in the matter of Commonwealth versus Karen Reed. Parties filing in. Let's get the notice of appearance. And let's get right into the subject matter of our discussions today. It's kind of funny. Look at the closed captions. Give your attendance and shall be heard. God say, call Mets. God is saying to call the Mets. I don't know why, but call the Mets. All right. So we start with the first argument, which is, are the notes from from Karen Reed's interview getting turned over? Short answer, yes, they are. And the short answer is it's proper that they be turned over. I get it. A lot of it. Understand it. The argument about all this, but here's the problem. She sat down with a reporter. She gave statements her statements, no matter in what setting, can always be used against you. I don't care if the reporter there's some confidentiality communication. If her statements are there, they are going to be usable against her in the future. At the very least, they get turned over. So we shall see. This lawyer was, I mean, you want to talk about,
As to the balancing test and the First Amendment interest,
I don't like when lawyers read off of paper, but I understand it. He's making his argument. He's got to make it compelling. It's not one of these that you're flying off the cuff. It's just trying to get something on the record. So the judge makes her ruling and says, I'm having these things turned over. But that really wasn't the fireworks of the day. The fireworks of the day came with the next motion. God, this was great.
This is the Commonwealth's motion for reciprocal discovery pertaining to employees of ACA.
No, not that one.
And
This one.
Expert, so-called expert, takes the lead.
We're doing.
That this search occurred at 2:27 is clear.
Hang on.
Without having an opportunity to dangerous affidavit, computer.
Sorry, give me a second, guys. I was
You want me to think about-
watching three streams today, trying to get this and doing work at the same time.
that, but why don't we hear the Commonwealth on its motion first?
Oh, this motion, by the way, was styled Commonwealth's motion to exclude, what was it? Commonwealth's motion to exclude defense witness Richard Green's debunked quote opinions. That was the style of the motion. So we getting spicy. Debunked.
Court, we filed a motion to exclude Mr. Green as a witness regarding 2 points. The first is a claim that a witness's phone made a search for a phrase to the effect of how long.
I have to speed Brennan up. I cannot do him at normal speed. I have to speed him up.
Died in cold at 2:27 a.m. And secondly, to exclude an opinion.
I gotta turn the volume up because this courtroom sucks for volume. See, I sped him up and the stream got mad at me. Sorry. We're just gonna have to deal with it.
2:27 a.m. And secondly, to exclude.
We're gonna let that catch up. It is motion to exclude a defense witness Richard Green's debunked opinions. Here's the thing. This is not a motion in limine. That would be untimely brought. This is not. This is a motion saying that this person is not an expert. So we expect to hear Daubert factors, right?
An opinion that there was some type of intentional deletion.
Okay. This is going to piss me off.
On number 3, he changes his characterization of what his profession is. He originally calls himself a forensic technician, and then the updated affidavit cites that he's a computer network technician. Now that is odd because usually a professional knows what they do for a profession. Simple explanation of what he does stands out. Also stands out when using technical terms. They either were wrong or changed from the first affidavit to the second affidavit. For example, number 9, he talks about the download as a full file system extraction, then changed to an Apple iOS full file system. My point is that when you look, this isn't simply misspellings or poor grammar. There are terms of art that are wrong between the affidavits or changed. When you're using the terminology of an item that is a forensic tool, such as break key, it is spelled wrong throughout the affidavit. And so it seems to me that Mr. Green's affidavit had some assistance in building it. And the tone of the affidavit supports that thought. When we look at Mr. Green's affidavit, it is not that of a forensic examiner, it's that of an advocate for the defense. When we look at his affidavit, there is quite a bit of advocacy, insinuations, and surmise, and conjecture, and claims that have no factual basis. But there is little on methodology. In ways, it is a very dangerous affidavit to simply make assaultive comments that a
It is a dangerous affidavit with assaultive comments. The comments are assaultive. Sir. They are assaultive comments. You assault me with your affidavit, sir. Unless you're rolling that shit up and smacking someone over the head, it's not assaulting anybody. Like the histrionics. This is fucking Judge Bev. She hates histrionics. What are we doing?
user did something, purposely deleted a very important phrase, how long to die in the cold, without any forensic data or evaluation or validation. Similarly, when we look at his affidavit, it is replete with accusations suggesting, but never proving, never providing fact, that there was some type of manipulation or tampering with evidence. Now, this is not the role of a forensic examiner unless there is proof, in fact, that happened.
And this is not a motion in limine. That's not what this is.
But when we look through his entire affidavit, we don't see any attachment of raw data. We don't see an updated report. We don't see any viable information that in any way supports his speculative accusations. And so the defense, without having an opportunity to Mr. Green prior to trial, stand behind these statements under oath, would like him simply to come before the jury, make these salacious comments, and then leave it to the government to knock it down. And that might be a common viewing the transcripts of this case, but the Commonwealth does not intend to simply let evidence come in that's not qualified, that's not factually sound, and then go knock down glass houses. That is not the approach the government is going to take to this case. Mr. Green is going to testify. He should have a report that is factually based with methodology supporting these claims, these narratives that he's proposing. Considering testing in this case, there are certain tools that are used. The defense wants to propose that there is some type of race that Mr. Green looked at or used more tools than
I don't know why it's doing this, guys. I've got solid bandwidth right now. So it's driving me nuts. Oh, and Sandy's telling me that I might have said that the judgment allowed the notes. No, not the notes. The notes, not the. Oh, okay, hang on. While this is buffering, just to clarify something from before. The notes from the reporter, the reporter's own impressions of the communications with Karen Reed, not admissible. Not admissible. The notes, not admissible. The notes taking down Karen Reed's statements. Those, not admissible, I mean, not discoverable. Those, the ones that are just Karen Reed statements, those are discoverable. That was the distinction. So this is going to drive me absolutely insane. So let's see if we can't make this work a little bit better.
considering.
No, I do not want to consider anything right now. I said I'm going to download the fucking stream. Sorry. Let's see if we can't do it this way. All right. YouTube doesn't want to cooperate. Fine. We'll just download. I mean, not download. Totally not doing that. And we're going to go that way.
Evidence is why this should be subject to a Lanigan hearing and why we are willing to call our own expert as well, so that the record is clear and the science and data is clear. Instead of doing validation or testing, relying on Cellbrite, what Mr. Green has done in section number 13 of his affidavit is stepped aside from methodology, and instead he cites that he called Cellbrite technical service. Now, this is the forensic examiner who is supposed to go through the process, and yet he defers it to technical support of Cellbrite. Technical support in Cellbrite he relies on to say that this artifact where this search is stored is appropriate. And he remains standing on that foundation as why somehow there's some validation that this search occurred at 227. But then when he learns that Cellbright, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason. I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance to Cellbright, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense touts, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. That gets back to the X-ray analogy. He is viewing data from many different programs to say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact is following, that the artifact is in Safari suspended state tabs, and then has the last interaction date time.
So here's the problem. You have one way of excluding the expert, and that is by saying they're not an expert.
And
not doing that.
Time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual. They don't introduce the manual. And he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, of the opinions by Mr. Whiffen and Ms. Hyde, because he takes shots at them or makes mention of them in his report, and yet he does nothing as far as validation to consider the arguments and dispel them. He does nothing in his affidavit to address the methodology. Quite to the contrary, when you see Mr. Whiffen and Ms. Hyde's reports, it isn't baseless opinions and advocacy of a side. When you look at their reports, it is replete with methodology, fact-based, information-based, the study of the particular device at hand. The contrast between the actual use of methodology that is reflected in Ms. Hyde and Mr. Whiffen's report and this affidavit is so clear. Now, there are two opinions that are proposed pursuant to this affidavit. The first is the claim that How Long to Die in the Cold was somehow inputted at 227. The only effort that appears in this affidavit by Mr. Green is in section 15, where he did a low-level analysis of the wall file. Now, I am not an expert, and that's why the court should hear from Ms. Hyde or Mr. Whiffen.
Why? Tell me why. Explain to me why. And use actual law to explain to me why. Not conjecture.
And Mr. Green, but a simple understanding.
Let's do this. We're going to pause. We're going to let that one catch up. We're going to do this. We're going to go to his actual motion, because the motion itself is pretty interesting. Not interesting. The motion itself sucks. It's just a bunch of argument on why an opinion was wrong. The entire substance of this motion is the opinion is wrong. Nothing in this motion argues that there was not a methodology employed. It is just that the opinion is clearly erroneous. And when you get down here to the law, an expert witness is not permitted to testify to matters beyond an area of expertise or competence. Good. Like it. Commonwealth asserts he's not qualified to render an opinion, claiming, okay, but under what premise? Are you saying he is not an expert and he cannot testify to these things? Is he saying there's no methodology utilized in making these determinations? What are you saying? You're just saying he's not allowed to testify to these opinions. Where's your law for that? Daubert Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify to these two debunked claims. I just cites the two cases Daubert Lanigan. It's the defendant's burden to establish that Mr. Green's testimony will assist the trier of fact to understand the evidence or determine a fact and issue, and that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented to the jury's consideration. So you don't like, and he says clearly the methodology or theory underlying Mr. Green's testimony is not sufficiently reliable to be presented to a jury for a jury's consideration. Here's the problem. You're saying that really pretty thing, where you're saying it's not sufficiently reliable and shouldn't be admitted. Why? Because he reached a different conclusion? You haven't explained how the methodology is flawed. Not in the motion. You don't address it. You don't contend that he's not an expert. You don't do anything to combat the ability that he has to get up and testify to certain things. So the entire argument that you are making is he's wrong. Okay. If he's wrong, then presumably you will crush him with the expert of your own, or instead on cross-examination. So you don't just get to use that and say no.
Information in a repository. And the description or misunderstanding by Mr. Green of the wall file is clear in his affidavit. In fact, he implies that there were 3 searches in his affidavit, number 16. Let's look at this phone that they were. Surprised that his second opinion is an attempt really just to create confusion, to disparage, and to make claims that are factually untrue. It's necessary to have this claim because number 1 doesn't have any resonance.
You said factually untrue. You know who decides what's factually untrue? The jury.
Leaving somewhere, somehow. Not uncommon. The claim or the opinion number 2 the defense would like the jury to hear is that somebody somehow, whether it was a person, presumably the witness in this case, or the police somehow manipulated the phone. I dare say there's no evidence to support that. And yet, in an affidavit under oath to the court, in an attempt of advocacy, this witness is comfortable and willing to promote a claim that has no factual basis. If a witness, an expert, is going to promote in an affidavit a claim with no factual basis, we should not trust, without vetting that witness, that their other claims have any merit or value. In opinion number 2, this expert, so-called expert, takes the liberty to say that the McCabe cell phone could have been manipulated. Not that it was, not that I did a study, not that I have a fact. It could have been manipulated, then rehashed after manipulation with the PDF being modified. Wow. It's an extraordinary conspiracy in the world of forensic science to be able to accomplish all of those tasks. So if he has no basis in fact or methodology, no good faith basis to make this assertion, why is he? Why is he? It is because the claims he makes in opinion number 1 are so scientifically and forensically unsound. This is a tactic to confuse the issue.
That sounds like a really good line of cross-examination that you would have in front of the jury. Like I said, sounds like something that maybe your expert could testify to in front of the jury. But it also does not sound like a reason to exclude an expert. So,
and think about the import of this baseless claim by Mr. Green. It is suggesting.
Is there a tally counter for how many times he says baseless? Can we do that? Is that his new trigger word? Is it baseless?
That a witness with no other evidence whatsoever was involved in a conspiracy to murder somebody. That's the implication that he wants the jury to be confused by. Otherwise, there'd be no other reason to make the suggestion. That is an extraordinarily harsh claim when we don't have any facts.
He says he.
How could one cause manipulation? There is scientific ways that can be explained how manipulation could occur, but we don't see any of that in this affidavit because it didn't exist in this case, because there was no deletion or manipulation by the witness. There was no manipulation by the police who processed this phone. If there was, there would be some proof. This affidavit speaks volumes by the absence of fact and data and science. Mr. Green does nothing to try to demonstrate that there was user deletion on this phone or that there was manipulation by the police. When you look at the data in the phone, the question arises, why is there a 624 search, not a 623 search? The phone stores the last entry into the tab. It's not just science, it's common sense. Common sense that Mr. Green ignores. And so not being able to prove user manipulation because it happened, he turns to police manipulation.
I'm turning my volume down. The court volume is boosted to 600% of actual volume. So this courtroom has always had bad audio issues. So I'm turning my audio down.
And he says that there can be a problem where the hashes don't match, but the problem is the hashes do, they match. He complains that he did not receive the PDF when he received the download. And because there was a production at different times, he then sprints out into a different universe and suggests that somehow it must be because there's manipulation. And again, doesn't prove it. There's actually ways that a real forensic examiner can look at the PDF, gray key file, and the phone and determine whether manipulation occurred. There's a program called XMP and another one called Magic. From most expert witnesses went through that process. No manipulation. But Mr. Green doesn't even go through the process to disprove his own theories. If he used methodology, he could simply dispel his own claims. It's either he doesn't understand the forensic technology to do that, or he chooses not to do it so he can just posit hand grenades throughout the case and let them resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all.
That sounds like an expert. Sorry, but that sounds like an expert opinion. Like that sounds like you would have, your expert come up and say that they're not anomalies. Sounds like that you don't like his opinion and you think it's wrong. Well, there's a way you do that, and it's called at trial. You put on your own expert and you say that expert's an idiot. My expert's right, that expert's wrong. It's just why are we here?
I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green's anomalies have no basis in.
Wait. Did did he just say the quiet part out loud? Hold on. I missed it.
Resonate wherever they fall. In an attempt to create some doubt or uncertainty or merit some conspiracy, he lists a number of what he calls anomalies, which are really not anomalies at all. I could go through each one of them. I could give a difference of opinion. I could show that Mr. Green.
Wait, what? Did you just wait? It's up there. It's on the screen. I can see it. It's actually it's actually captioned, like the closed caption. Got it. I could give a difference of opinion as to each one of the anomalies. Well, that's pretty fucking amazing. Yeah. Because it's an opinion that he formed. And you don't like it. And you could give a different opinion. Because your expert can give a different opinion. You said the quiet part out loud. Your motion should have been, I don't like these opinions. Please make it stop. That's what it should have been.
Green's anomalies have no basis in fact, but suffice to say, I think this should be done by qualified experts, and that's why there should be a Lanigan hearing. There is such misunderstanding of forensic science in Mr. Green's claims and anomalies. If he's going to make these assertions before it goes before a jury, he should sit in the witness seat under oath, as the Commonwealth witnesses should as well, and he should justify, explain to the court why he did not engage in methodology and how he has come to these extraordinarily baseless.
Sir, you keep saying a word that I don't think you're using properly. How he didn't engage in methodology. You engage in methodology when you speak out loud. Methodology is something we engage in all the time. Like, example, methodology. Your brain is processing something that's about to come out of your mouth hole. There's a processing that takes place. That processing then goes down, and then it reverberates in your voice box, and then vocals come out the mouth hole. That's a methodology. You keep saying methodology like it's this magical thing. No, I use methodology when I brush my teeth. Like, I go in and I put the toothbrush there and I hold the toothpaste and I use the methodology. There's a methodology to everything. You just keep saying this word like that's magic. If you say there's no methodology enough times, it will agree with you.
Was inaccurate and prejudicial claims. The Commonwealth has to, the court rather, has to look at Lanigan and whether or not a hearing is appropriate in this case. When we look at the different non-binding factors of Lanigan, we look at number one, whether it has been generally accepted in the scientific community. The software has been generally accepted in the scientific community. So hasn't the effort of a forensic examiner, the expertise. And the defense complains in their motion, the Commonwealth has not properly addressed the methodology of Mr. Green. Well, the reason why is Mr. Green does not provide any methodology. So this is the way to address the methodology. Number two.
Bro. Stop using the word because you clearly don't understand what it means.
The opinions have been or can be subjected to testing. Well, we see Ms. Hyde and Mr. Whiffin's report directly contradict the assertions, the unsupported assertions of Mr. Green. There is no.
Oh my God. No way. You mean your experts come to a different conclusion than their experts? A directly contradictory conclusion? Color me shocked. Every case with any expert ever.
Testing that his opinions have been subjected to. There is no peer review. There's no other alternative support for his opinions. They're just broad, baseless claims. Number three, has been subjected to peer review and publication. Certainly the science, the forensic science has, the software has, but the interpretation and Mr. Green's interpretations, it hasn't been subjected to anything. In fact, it changes. Has an unacceptably high known potential rate of error. Well, if we see and read Ms. Hyde and it's just a high level of error. It's gross error. It's total error. It's wrong. And is governed by recognized standards. Well, if you look at the history report that the defense filed as an attachment, it talks about a forensic examiner's obligations to verify, to test.
Yeah.
Things that Mr. Green didn't do. Their own report that they offer in support undermines the idea that Mr. Green did anything to validate or support his opinion. And as we see from both Selbright, he does not follow the protocol. He does not follow Axiom or the guidance that they give him. He sidesteps both of them to give the opinion he wants to advocate for the defense. At every turn, positions of Mr. Green are not only unsupported, they're unverified. And so what arises from this subterfuge is that Mr. Green is really just a
subterfuge. Okay, here's the thing. I had a decent opinion of Brennan, and I'm still going to hold out hope for a decent opinion of Brennan. But right now, he is just an attorney that's instead a child that's having a tantrum up there. He is stomping his feet. I mean, literally, listen to what he's saying. He is stomping his feet, using big words that he doesn't understand, stomping his feet, using big words, and saying, I don't like what that mean man says. And because I don't like what that mean man says, the jury shouldn't have to hear it, and I shouldn't have to deal with that mean man's words with him on the stand. So please, judge, I'm going to shove my hands in my pocket. I'm going to be really upset, and I'm going to stomp my feet and really, really mad. I'm going to say, please don't make me cross-examine this man because he's wrong, judge. Methodology. Hashtag methodology.
vessel or an attempted vessel for the defense, third-party public defense. It is not lost on me. I'm not unmindful of the date on the phone being a search Holland Diane Cole that occurred at 6 a.m. in that morning coincides with first responders' testimony that the defendant herself was asking these very same questions around that time about Mr. O'Keefe and how long he could survive the cold. Under the extraordinary broadness of circumstances in the depth.
Breadth. The word you were looking for is breadth. Breadth of circumstances. This is the problem when you start trying to use very large words and you're just trying to use them for effect. You use them in the wrong way. So it is better to stick to the small words that you can use effectively than to just use big words like methodology and broadness when you can better explain things. Hashtag methodology.
Of the amount of witnesses and information in this case, it is hard to think that that just happened by happenstance. That there is a inquiry, something forming in the mind of the accused is then shared with the witness, Ms. McCabe, and in response, she makes the search, which is entirely supported by all the credible forensic evidence. If Mr. Green is going to be witness in front of the jury in light of the fact that he has no methodology and he's wrong on the science, in addition to the fact that he wants to now appear as advocate for the defense and accuse everybody and anybody without articulating who, just anybody other than the defense, he should have to stand behind those claims under oath. And so I'm asking for a landing and hearing. We are not shying from our burden. We're more than happy to bring in a witness so the court can contrast the two. Thank you.
All right, thank you. Mr. Lassie?
Hang on. I gotta do something. Hang on. The entirety of that argument can be summed up as follows. All of that. Just the entire argument. Just that's where we are. Or I got a better one. It could be that. It's that. Maybe it's that. Just the melting down. This is patently unfair. Judge, do not allow them. No, we can keep going. Yeah. So there. I feel like that was an accurate depiction of that argument. Judge, I don't like what that expert says. It is wrong. Please don't make me face that big, mean, mad, bad man. Like, I don't want to do it. Now I completely understand why Alessi was so pissed. He's fucking mad. Oh yeah. Yeah.
May it please the court. Mr. Green is eminently qualified to provide testimony in this case with regard to the subject matter that has been challenged by the prosecution in this case, and that is with regards to the search, house long to die in the cold, that occurred at 2:27:40 a.m. on January 29th, 2022. Mr. Green, and I want to cover the baseline for this hearing first. Mr. Green testified at the first trial. He testified without objections as to his qualifications. He testified without objections to his methodology. Your Honor sat, obviously presided over that trial. Your Honor did not issue after his testimony any limiting or curative instructions with regard to either his qualifications or methodology, nor did the prosecution after his testimony stand up and ask for any such limitations or qualification. The baseline for his qualifications and methodology was established, again, without objection.
But they are being challenged now.
I was just waiting, Your Honor. They are being challenged now, but the reason I state that is because what Mr. Green has provided in response to this motion is even more detail than what happened in the first trial. In Mr. Brennan's argument, he did not make one argument about Mr. Green's qualifications. Zero. So I'm assuming, because there's nothing in their
Oh, I love the sarcasm. I just fucking love it. No, he didn't say shit about his credentials, so I'm now assuming that they're just going to go ahead and stipulate he's smart as hell. Oh.
motion that even goes into why he might not be qualified. So to me, Your Honor, that's a tacit concession, if not expressed, that he's qualified. And of course, he has to be qualified in digital forensics because there are 5 other areas of digital forensics opinions and methodology that Mr. Green is testifying about that has not been challenged. So to me, it is rather odd right off the jump that there's no challenge to 5 other areas of data forensics, and there's just this challenge to one aspect of his whole testimony and opinions. I have provided Your Honor with 2 exhibits, demonstrative in support of my oral argument. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, and Exhibit 2 is entitled Digital Forensic Product Tools Used by Witnesses. The Commonwealth has agreed to my use of those exhibits. They had some, I agreed to theirs, and I would like to, Your Honor, use those in a moment. The Commonwealth, in its oral argument, said 10 times just now that there's no methodology and that Mr. Green does not articulate a methodology. That is incredible to me because the opposition and Mr. Green's affidavit, in fact, are replete with the methodology. And here is the key, Your Honor. While Mr. Brennan challenges the methodology, none of his witnesses, neither Mr. Whiffen nor Ms. Hyde, challenge the methodology. As a matter of fact, in their 2 reports, neither of them even describe Mr. Green's methodology, nor do they challenge it. And of course they can't, because it's the same exact methodology that they use. And that's what I would like to go to now. Exhibit 1 is entitled Digital Forensics Methodology Regarding Subject Artifact, J. McCabe iPhone Data. And I prepared this. This is just what's in our opposition. It's in Mr. Green's affidavit, but it summarizes what the methodology is that we're talking about here. What is that methodology? Step 1, you receive, and this is to answer the question about what is.
He's properly using the term methodology. You see, he started with steps. He started with steps. He said, step 1, what do we do? I like this. This is proper methodology. When a lawyer gets the opportunity to break stuff down and be like, Judge, this is as simple as A, B, C, D. Let me spell it out for you and break it down in crayon. It's always a good day in court. This is just.
Is the proper interpretation of the artifact in question that everybody agrees is the artifact. Step 1, receive a full file system image of extracted data from the Commonwealth. For example, the defense received it on a USB thumb drive. That's undisputed. If you look at the reports of Ms. Hyde, you look at the reports of Mr. Whiffen, they all say they received a full file system image of extracted data. So step 1 in the methodology that everybody agrees to, everybody agrees that occurred. Number 2, verify hash signature value of image file of data received. This is very important because hash values with regard to forensic data is extraordinarily important for it to be proper because it's the signature, the fingerprint that allows data forensic examiners to be sure that the data that they're giving is sacrosanct. It is not possible for manipulation. The common
Speak technology to me, please. This is music to my fucking ears. Just like I said, Give it to me in crayon, please, because this stuff can be very convoluted, and all Brennan got up there and said was methodology 9 million times, didn't understand what the fuck he was talking about, and then just kind of sat down and said bad. This is just magical, because it's like, hey, we're just going to go ahead and say what it is. Step 1, get phone. Step 2, get phone file. Step 3, verify phone file. Step 4. And it's like, methodology me. Is that a thing? I don't know. I've been methodology. we're methodology. This is just fantastic.
Commonwealth just said that Mr. Green has hurled several accusations without a basis, one of which regards the potential for manipulation of data. And it's remarkable that there is even an issue about this dispute. Mr. Green did put in his affidavit an unprecedented situation, and it is this. Mr. Garino, Trooper Garino, in his April 2023 report, which is an exhibit to our opposition, states that when he got the phone of Ms. McCabe, he used Celebrite UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens...
Bro, Alessi is making his points so firmly that it is shaking the camera. Every time Alessi hits the podium, the camera shakes. No, do not do this. I demand more Alessi.
UFED, a tool of Celebrite, to image the phone. And that's all he sent to the defense in the beginning. Why is that unusual? Because what happens in every case, without exception, is that the law enforcement sends the raw image, original data that has the hash signature on it. And the hash signature is an algorithm that produces, they call it, in this case, SHA-256. What it is it's a stamp of reliability that says, as soon as we got this data, we immediately processed it the proper way and put a hash signature so that there can be no contest. What the Commonwealth fails to tell the court, Your Honor, is...
That's the feed, man. The feed was brutal today.
And that leads any proper data forensic investigator to question the integrity of the data. If you turn to, Your Honor, Mr. Whiffin's very long December 2024 report, which is Exhibit 1 to the Commonwealth's motion on page 3, and I'm going to read it verbatim. This value is talking... Here's the key point. However, this requires authentication of the original hash value, which is not possible with great key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication. That's all a fancy camouflage way of saying, Mr. Whiffin saying, I can't validate this hash value because of the way Trooper Garino processed it. Do it, Mr. Garino, Trooper Garino, the right way when he got it. And why is this of concern?
This is great, because this is also the lawyer drawing attention, and this is a preview of cross-examination of their expert found the same shit. Like that we can't say that this has not been tampered with. Here's the thing. The expert is sitting here saying, I can't say it's been tampered with. I can't say it's not been tampered with. That's this. It's the same fucking thing. They're saying the same damn thing. They're both making the claim. The suggestion of authenticity. You know what the suggestion of authenticity is? The possibility of manipulation. I'm not saying that's the case or not. But shit, like, you're saying the same thing. Could it have been manipulated? Yes. Is it possible it wasn't manipulated? Yes. Also true. Oh my God. Shocker.
Concern. add to this point that's conceding that the hash value in this data cannot be validated. How did the defense get this? When Mr. Garino used the Celebrate UFED reader, all he turned over in the beginning was the UFED reader report. He didn't turn over the data, the full. So Mr. Green had to ask for the data. Then what happens, misstep number 2, Trooper Garino only provides a PDF of the hash value. He used gray key, which was a mistake, because gray key, you can't get the original hash value. Mr. Green had to go back a second time and say, no, we don't want just a PDF. We want the full extraction. Finally, after the second time, the defense got the full extraction. And that's when we discovered that the validation was improper. It's not Mr. Green that is coming up out of thin air with these issues. This is the job of a data forensic person. And the first principle is to see whether the data is valid. So not only does Mr. Green justify in his affidavit why there's a big concern over this, Mr. Whiffen concedes it on page 3 of his report. That starts, and I'm going to get to it, all concerns now about the data and deletions. But that's the foundation for it, and it wasn't caused by the defense. It was caused by Trooper Garino, who didn't do this properly. And with regard to the methodology, I want to go back to Exhibit 1. So importantly, Your Honor, 1 through 4 of this methodology is undisputed by all of the data forensic persons. Mr. Whiffen, Ms. Hyde, and Mr. Bean all agree on 1 through 4. They all agree that this is the methodology. Number 3, once you get the image of the file, each examiner saves the image to their lab storage system. Some use computer servers, some cloud storage. And 4, the methodology, you then process the data with appropriate tools. Nobody disputes that Celebrite Physical Analyzer and Magnet Forensic Axiom are 2 of the many tools that are available to use. There's a dotted line that I put there, Your Honor, because 1 through 4 is undisputed by all 3 data forensic examiners. Number 5. And 1 through 4 is usually all one needs to do as a data forensic examiner. But Mr. Green went on to do more.
But wait, there's more.
Number 5, further processing of data as warranted. And he explains why it's warranted here with additional tools. So he then went on to use Sanderson Forensic Browser, ArtX, Belkasoft X, and then he didn't use iLeap. Ms. Hyde used iLeap. So it's important to line up the methodology. I just don't understand how it can be stated that there's no methodology stated. Not only does Mr. Green state it, we prove undisputed that everybody agrees this is what the methodology is. And that is what is so flummoxing as to why we're even here, because the methodology is agreed upon. What is disputed, Your Honor, is what are the opinions from when you apply the methodology and you apply these tools. So
thank you. That is that. So I go back to my original point. Why are we here? Why are we here? If the substance of this motion is the exclusion of an expert from testimony at trial, you must combat the expert's credentials, the methodology utilized. The substance of their opinions is a matter of fact for the jury to determine whether it's true or not. Now, if the substance of the opinion is reached by a non-method, like if you're just throwing a dart at a wall and that's your opinion, that's different. But as we've just heard in very neatly articulated methodology, 1, 2, 3, 4, 5. I love steps. They're great. They're fantastic. There's a basis for the conclusion. And you don't agree. Congratulations. It's wonderful. You have that right. You don't have to agree. You can put on your own expert to say that person wrong. And yeah, so what we don't know, it took me 3 hours to teach enough CS on why that search didn't occur. Prosecution isn't equipped to explain this through experts. It's not easy. This is remarkably complex, which is why we use experts. And this is why it's really important to get an expert that's articulate, because holy crap, is this shit complicated. Lindsay makes the point. Let's discuss the methodology of leaf blowers and red solo cup, shall we? Talk about baseless opinions. It is rich to me. It is rich to me that we have the Commonwealth now combating Dr. Russell, the cell phone experts, all of them, and saying these guys are quacks. They don't know what they're doing. When they have Trooper Paul, who's like, I maybe took a class a couple of months ago that maybe taught me something about cars. Or evidence gathered by Red Solo Cup put in paper bags. Or a leaf blower used at a crime scene where you're trying to discover little bits of evidence. I mean, talk to me about that methodology. Now, here's the thing. The leaf blower, the Red Solo Cups, those aren't really experts there, but it's Trooper Paul coming off and being like, I'm an expert. Where you get the, is it insulting to like reference the Ralph Wiggum, that voice? Just, I'm an expert. I choose you. So, Billy's mom's yelling, but he used the methodology for his temper tantrum. He did. That's the appropriate methodology of a temper tantrum, which is to just wind up, rage, and then kick the floor and be very angry at everything.
Interestingly, it is Mr. Whiffen who provided the most lengthy report in this motion. Mr. Whiffen only used 2 forensic tools. He only used Celebrite Physical Analyzer and his own software, Ardex. That's it. What I'd like to, Your Honor, is ask if I could, please, if you could turn to Exhibit 2, which is entitled Digital Forensics Products Tools Used by Witnesses. And I just want to make sure Your Honor has that.
Okay.
So I prepared this demonstrative exhibit to show the tools that all parties used. And the purpose of this is to show how closely Mr. Green and Ms. Hyde match up with the tools used, and how insufficient Mr. Whiffen and Mr. Garino are. So if you look at the left-hand column on Mr. Green, and I color-coded it to try to make it easier, you see 7 tools used by Mr. Green. You see 6 tools used by Ms. Hyde in May of 2023. Many of her tools exact same as Mr. Green. You see Mr. Whiffen, who used really 2 tools, but to be conservative, I listed them as 3 because they're just different versions of Celebrite Physical Analyzer. And then Mr. Garino, Trooper Garino, used 2 tools. But here's what's really important and I think remarkable that springs from this chart. Mr. Green did more, had a more encompassing and comprehensive review than any of the witnesses here. And back to Exhibit 1, he did 2 more steps in his methodology than everyone else. So 1 through 5 of the methodology, everybody did. 6 is analyze overall user activity, artifacts of interest, timelines of interest, and anomalies such as deleted data. 7, reporting as appropriate pertinent artifacts, other artifacts. For this motion, Mr. Green did 6 and 7, and no other witness did that. The issue in this case as to whose interpretation is correct is an opinion issue. It is not a methodology issue. And Mr. Green makes that very, very clear in his affidavit that the difference is in opinions. Interestingly, on the very key subject of whether the artifact and the interpretation of it is a difference in methodology, a difference in application of methodology, or an opinion, which is not the subject of a Dalbert Lanigan hearing. Opinions are not.
Okay, we're gonna have to fast forward because he keeps going on this, and I can only listen to a Leslie slam dunk for so many hours. But this was probably the most brutal, joyfully unnecessary smackdown of a really stupid argument.
allegations made by Mr. Green, which are all supported, every single one supported with facts. But what the Commonwealth didn't tell the court is what the request was of Ms. Hyde. I just went through all the tools she used, why she used them, why she said it's best practices, why you use all these tools. What does she do now in December of 2024 to assist in the myopic approach of the Commonwealth to say, here's our studies, we only look at Celebrite Physical Analyzer, and it's gone, the search is gone, right? And we know why it's gone, because Celebrite, Mr. Whiffen, concedes that he went back and talked to the researchers, and what we have, Your Honor, is a total black box. And I'm going to point it out in a moment. Why is this no longer appearing on Celebrite Physical Analyzer? We don't know the answer. All that is stated is a bold conclusory statement that it's no longer reliable. That's it. We don't know why it's no longer reliable, but we know it's gone. And Mr. Whiffen never says, even though it's gone in one, he doesn't even address the other 4 or 5 tools where it still appears. It still appears. Now to Ms. Hyde. Disquietingly, on page 3, look at the request, please. The request was to understand changes made in newer versions of Celebrite Physical Analyzer to artifacts pertaining to the timeline of a Google search on January 29, 2022, namely House Long to Die in Cold. That is stunning. The request to her was simply to look at one tool that everybody knew by then.
Yeah. So why are we just one instance? We're not doing anything else. We're just looking at this one thing, one tool, one analysis. How does this happen?
And Celebrite had deleted it in their program. She then looks at evidence analyzed, second paragraph. This full file system image was processed with Celebrite Physical Analyzer, version blah, 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 decoding engine, etc. Where is her analysis of Axiom that was in her May 2023 report? Where is her analysis of Sanderson? Where is her other analysis that if she went and did it, she would have to say it's still there? So what she goes on to say is very interesting, but it's buried, and here's what it is on page 4. After she goes through and states what everybody knows is Celebrate just went back and for some reason deleted it, she says under the chart, while manual analysis of the database still shows a 22740 AM ET timestamp, the determination in prior analyses and from Celebrite is that this timestamp does not demonstrate that the URL was visited at the time of the last visit timestamp. So here she did a manual analysis and it still shows up, but she doesn't explain the significance of that. If we want to talk about reliability, Your Honor, the real question should be the reliability of the prosecution's witnesses in Celebrite Physical Analyzer.
Oh, shit. Okay.
So are you telling me that we should have a hearing?
Your Honor.
Judge Bev is like, I think Bev is at this point, she's like, you made your fucking point. But he's just going to keep on winning. I mean, he's just going to keep on dunking. And honestly, when you're having that much fun, because there's no way, yes, he's angry, but there's a part of him where it's like angry fun, where you're arguing, you're angry and you're arguing, but you're also like happy that you're arguing because you need to make the point. And
there's no need to have a hearing, and here's why. There's no need for a hearing because there's no disagreement on the Daubert issues. The dispute over what is the interpretation of this data, what are the people's opinions, is never one for Daubert. If that were the case, there'd be a Daubert hearing on every expert because experts, almost by definition on each side, disagree on the opinions. We don't need a hearing, Your Honor, because they agree on the methodology. They agree that more tools are better. They agree that the difference is at the very end of the analysis, which is the opinion. So in terms of the issues with regard to Mr. Green's report, which is my final point to get to, there's been so many mischaracterizations by the Commonwealth this morning of what Mr. Green did and what he said. So what does he do? He says, and Your Honor, digital forensic analysts are the equivalent of a medical examiner. Their job is to apply the methodology that is agreed to. Their job is to use the tools, everybody agrees on it, and then they're to give opinions on what those mean. And everybody here has the same data, right? If everyone's got the same data that they're using, so there's no dispute over that. The Commonwealth said that there's no factual basis for what Mr. Green did. There's a factual basis for everything, and it's undisputed. So everyone has the same data, and this I call the NB postulate. And the NB postulate is, why are people using different tools, etc.? It's because nobody has the source code for the Apple phones. So you use these tools to try to help interpret what these source codes mean. And it's an accepted methodology to do it. But the data, once it's produced, and we have an issue about what happened before it got produced, but in terms of the methodology that was applied here in the tools, there is no disagreement. So what, Your Honor, would an evidentiary hearing do? We're just going to come in and have witnesses talk about their difference of opinion? That's not what a Daubert is for. There's no basis for an evidentiary hearing because there's no dispute over the methodology. I've done a lot of Daubert hearings. I've never even gotten past a motion, let alone an evidentiary hearing, where the experts don't disagree on the methodology. So what is it that caused Mr. Green to raise questions? And again, I said data forensic examiners are just like the medical examiners. They don't look at just the body of the medical examiner. They look at circumstances surrounding it and all information. Well, that's what digital forensic examiners do, and that's what Mr. Green did. So there's great criticism of Mr. Green from doing what is proper for a digital forensic person, and it's a bit of a camouflage, respectfully, because the December 2024 reports of the Commonwealth now myopically go down to just one tool. So what did Mr. Green say that caused him to say,
Look who's here.
I'm just here to make sure you don't get any sleep.
That's fine. It's fine. You came at the, have you seen this hearing yet today?
I have not. This is on my list of things to watch before Monday.
Oh my.
So
okay. Shall we recap a little bit for Ian? I think we should.
I think yes.
You know what? It's easy. Let me memorize the timestamp. So timestamp here, because we can sum up Brennan's argument in about 2 minutes, we think, right? Not hard. So we are currently at 2:06:20.
Like there's too much. Let me explain. No, there's too much. Let me sum up.
Let me sum up. Let me go back to this because I just want to. Where are we with Brennan? Because Brennan's annoying, but we have to hear him for at least a second to go. This is a motion to exclude
the thing is I think we'd be standing Brennan if he wasn't on the side he's on.
No, not today. Not today, sir. No.
Fair.
Brennan lost all standing. Brennan is no longer stand. Not today.
Okay, fair enough. And somebody is saying that they're upset that the tie is not on the tie spot. The tie is still in my luggage because I haven't unpacked yet because I was sick all week and Mrs. Runkle is even more sick. So yeah, that is where the tie is it's in my luggage that I got to unpack when I feel up to unpacking. So
yeah, no, we are not standing Brennan today.
Okay.
Because he's unstandable today.
You couldn't stand him?
I don't know if I just walked into something or not. I'm not sure.
It was a pun.
Oh, I couldn't stand it. Oh. That's above my head right now. I can't comprehend that. No, but I was summing up for the chat the substance of Brennan's argument, and it is basically just I was pulling up stuff like this. Like it's just this. It's just a child having a tantrum.
Okay.
Affidavit to simply make.
And there's a danger. The affidavit is dangerous and it is assaultive.
Wait, how does an affidavit?
The only way an affidavit can be dangerous and assaultive is if I curl the affidavit up into a
like a stabby
thing.
Point.
Yeah, and then it can be assaultive. He says methodology 9 million times.
Remains standing on that foundation as why somehow there's some validation that this search occurred at 2:27. Then when he learns that Cellbrite, after actually doing analysis and study and updates and engage in methodology and review, determined that the way that was assessed is unreliable and the program has been updated, which no longer shows the 227 search at 227, and I'll explain why for good reason. I'm sure the court has heard this before. Mr. Green then denounces the very source that he relies on. And so on one hand, he's saying, I relied on technical assistance to Cellbrite, but then when they told me what I didn't like, I can ignore that part. He then defers to Axiom. Axiom, the government, the defense house, is a separate source that reinforces the same point when clearly it doesn't. You can see in number 14 of Mr. Green's affidavit, he talks about the fact he uses these different programs because he wants to view data. And that gets back to the X-ray analogy. He is viewing data from many different programs to say the same thing, but he never goes on to analyze it. What is troublesome about his affidavit in section 14 is he attempts to use resource material to convince this court that rather than methodology, these summary statements are something that the court should rely on. And so what he does is he takes an excerpt, page 7 of his affidavit, number 14, and he says that the Axiom user manual describing the artifact as follows: that the artifact is in Safari suspended state tabs, and then had the last interaction date time, and the date and time of the current tab state when it was last interacted with on the local device. And so he's taking a piece of the manual, you don't introduce the manual, and he tries to use that to buttress that this search happened at 227. What you're not offered is that in the Axiom notes, in their artifact reference guide for the description of Safari suspended state tabs, which he's referring to, this is the death knell, really, the analogy that the Safari suspended tabs contains the current state of each browser tab in Safari that is currently open on the local device. The date and time are only updated when the user interacts with that tab on the local device. Since these are local tab states, results in the artifact may contain an earlier date and time compared to the result of the Safari history artifact if multiple devices on one iCloud account. And so, by Axiom itself, it makes clear that an artifact in a tab can reflect a time that is much earlier than the actual search. And this has been presented to the court. We've provided the trial transcripts of Ms. Hyde and Mr. Whitman. When a tab is open, many tabs can be open. It is open at a particular time. And if that tab is reused.
So now you get a little preview. Have you gotten the a gander basically that he just has a disagreement with the opinion?
Yes, which is not grounds for exclusion.
Exactly. Did you hear a single thing that said that he did not? Well, did you hear, other than just the broad assertion, to borrow a word from Brennan, that he didn't use methodology? Have you heard anything about the methodology he used or didn't use? No.
No.
So the entire point of his argument, which I just did the math on, was like 20 minutes. So 20 minutes, he makes the argument, says methodology a lot, doesn't say what that is, and then just says, I don't agree with this person. At one point in time, he says, and I can go through each one of his opinions and have a contrary opinion. It's like, well, that's kind of what a trial is for, what a jury does. So no, he does that for 20 minutes. And then, then Alessi gets up and let's see. So he begins, so he goes from 1 hour until about 1 hour and 25 minutes. And Alessi gets up 1 hour and 25 minutes. And Alessi continues to talk for what? Another 40, almost an hour, 50 minutes, almost an hour, 45 minutes, 50 minutes. So 20 minutes of argument. And then Alessi comes up with like 40 minutes of slam dunking and just completely annihilates the Jesus out of Brennan. So basically, why are we here was the contention that I was left with. And we're now just watching the end of Alessi's argument.
These aren't things you normally see, and they're not explainable. Here's the last point I'll make, which there's also agreement. There's this deletion of this one search. Mr. Whiffen can't explain why. He says, well, maybe it was a spontaneous deletion. There's no such thing in data forensics as spontaneous. And he doesn't cite me. Maybe it's because the search didn't load. Maybe it's because there was bad connectivity at where the search occurred. Well, that's interesting because a harder thing to load, the image that came up with food, did load. So you got to have stronger connectivity to get an image that dense. So what Mr. Green simply points out is that doesn't make any sense either. That is the essence of Mr. Green's affidavit. And Your Honor, just to be clear, when we sent in the second affidavit of Mr. Green, we put in the cover, and Your Honor may not have gotten this, that it was to replace the first affidavit because there were some typos, et cetera, et cetera. So you'll see 2 dates of the affidavits, and it's the later date, and I'm going to give you the specific one that controls.
Oh, I have both.
Okay, right. Yeah.
The second one on the body of it does not say it's a supplemental or anything. If it was in the cover letter, that's what they're both docketed, so they'll both
I
remain
was just
docketed.
going to say, we wanted to have them both there for whatever purpose Your Honor wanted, but there's been some question about why 2, and it's a simple explanation, one supersedes the other. So Your Honor, in terms of, and this will be the concluding part of my remarks. In terms of the allegation that Mr. Green.
Where was this? My goodness, why is he yelling? He's yelling because he's pissed he has to be there. Because none of the argument that was offered by Brennan is in any way comporting with the law that surrounds whether an expert can or cannot testify. It was simply Brennan getting up and stomping his feet and saying, please don't let that big mean man take the stand and say things I don't want him to say.
Being wrong isn't sufficient. You've got to be unscientific.
Yeah. So that was, we didn't hear any of that. None.
Relies upon technical support at Axiom, and he relies upon technical support of Axiom and the statement that is just remarkable, that that's the basis for his expertise. Mr. Green makes very clear that he did his own analysis. He used the tools himself, but here's why he called Celebrite. At the time of trial, Celebrite had 2 versions of physical analyzer on the market at the same time. One physical analyzer 7 showed the 22740 timestamp. It showed it, and it showed it in a deleted state. But the recent one, the one that Celebrite updated 1 week before trial, didn't have it. So that was the Insights, spelled oddly, INSYEES. That didn't have it. So Mr. Green did what any good digital forensic person would do. He called up support and said, well, what's going on here? You got one that shows it, you got one that doesn't. But he did what the NIST standards, the National Institute of Standards, and that's attached to Mr. Green's affidavit, says that good digital examiners use multiple tools, and when they have questions or they see anomalies, you call up the program people, you talk to their technical support. That's not someone inexperienced and relying upon them. That is the proper methodology. So Mr. Green did that to corroborate and get explanation for what he found. So in sum, Your Honor, here is what is before the court and what is pertinent for this motion. What is pertinent is the inquiry under Pope, which Your Honor cited in your decision on Dr. Russell. It comes down to, is Mr. Green qualified? There's not even a contest. Second, is his methodology reliable? And Your Honor, those are the only 2 subjects that are ever proper for a Daubert hearing. Why would we have what will be a very long hearing? Now, Mr. Brennan suggests bringing in Mr. Whiffen. I've never heard of that happening in a Daubert hearing where one party challenges the witness of the other and then says, by the way, I want to bring in my witness to show. That never happens in Daubert. It's the person.
I wouldn't say never.
Well, let me take that back. Good point. I won't say never. It is so unusual to have that happen under these circumstances. And this is the key, Your Honor. Why would we have a hearing about whether his methodology is proper and reliable if all of the witnesses agree what the methodology is? So, Your Honor, in conclusion, I would.
This, I think, is why she says there's no Daubert hearing.
To deny the motion.
Oh, you can't. I was keeping the chat at bay.
Oh,
I didn't
thought
leave
they
with
do.
that.
I'm sorry.
Come on. It's also the way she does it too. Come on, let me set it up and knock it down.
Commonwealth
All right,
received
fine. My
You're
bad.
right.
Mr. Green on 1 of 6 data forensic.
I'm coming in
issues.
late. I thought you
He's gonna
already
be
said.
testifying, obviously, at this
Yeah.
trial, and I would urge your honor to not have the evidentiary hearing because your honor has before you everything your honor needs to perform the gatekeeping function. And again, it's almost all undisputed with exception of one thing, and that's the opinions of the expert, which is never proper. I will respectfully state that never is appropriate for a Daubert hearing. Thank you, Your Honor.
Okay, any follow up, Mr. Brennan?
I do. A little bit of knowledge of forensic data analysis can be dangerous. So when you hear representations or arguments that Mr. Whiffen's opinion that there may have been a connectivity issue is undermined because there was a picture of food which is suggested through a application search, misunderstands the basic premise that that's a cache picture. And that is meant for the user of a phone, for the user experience. And so there is cached items that are available without connection that register and come up quicker from a different source while it's waiting for a search to be conducted.
Am I the only one that got irritated when he said cached? It's a cached picture. Like,
You're not wrong.
You got up there and you said a little bit of knowledge about forensic examination of cell phones is a bad thing, and then you said cache, which means like you said that one, and then you said that one. That undermines
You're like,
your
one of these
argument.
things is not like the other.
Uh-huh. So I just no, it's cash. It's cash. Like cash. Like it's cash.
Docket. It's simple. It can be explained. It's science. It's data. So when you take a little bit of data and you twist it because you misunderstand it or you want to advocate, that is the danger, and that's why it's best left to experts. What the defense apparently is mistaken about is that using a number of tools does not substitute for methodology. You can use one tool, you can use 30 tools. They're all going to say on the timestamp that how long to die in the code occurred at 227 on that browser. That is the time that was open. That window was open at 227. But you can't just look at 8 different tools that are all going to say the timestamp is the same. You have to look into the data and into the databases, knowledge C, the history, and you have to determine what artifacts exist to show that occurred at that time. And when you do that in this process, it is clear that 227 search happened after 6 a.m. in the morning. And so that's what Mr. Green doesn't do. He doesn't engage in methodology at all. There's an agreed methodology. He doesn't use it. The defense points to Ms. Hyde's report, how it's narrow. It's narrow because it's an addition to her 2023 report. Mr. Green has not written a report. He has not provided data. He has not provided.
Cody Light, thank you. I knew I wasn't the only one that was pissed off when he said that. Cash and me. I'm so nervous of prayer, but like you have no idea. I want to throw a monitor at him. Yeah. You were not alone. I 1000%. Yeah.
Provided that he's used methodology. He has not engaged in the process of studying the data. He made a couple of phone calls. And so you can't simply look at the timestamp and then give a reckless opinion not based on the methodology. We still haven't seen a report from Mr. Green. There isn't. Because if he actually does the testing, takes a phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern.
And it's right there. You know, usually law and crime, the closed captioning isn't always the right on. They got it right on here. So 2 points. One, he says if he doesn't do it, then we'll do it for him. That's at trial in front of a jury. That's the appropriate way to challenge expert opinion as being wrong. But if you're looking at the, you know, there is no hashtag concern. We're not talking about hashtags concern. Hashtag methodology.
That will phone and tested his hypothesis, he would dispel his own hypothesis. And if he doesn't do that, we'll do that for him. There is no hashtag concern. And when the defense raises issues, postures, ideas, we never hear what the problem is. What is the hashtag value? Who manipulates it? And that is the MO. Blame anybody. Don't articulate who. Be like a ghost, evasive as possible, and then when it gets knocked down, just posit a new theory. The government offers to bring in Jessica Hyatt next week or even with at another time. Is it common? No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy.
He just uses a lot of big words that he does not have the comprehension to use. It is more effective to use small words and make your argument, at least when you understand them. The accuracy of the fallacies. Excuse me, what? Wait, what?
No, it's not. It's because the government has no fear of a hearing to help educate the court on the data science that is at play here. And so while we don't need to, we have no reluctance to. So there is a real accuracy on the fallacies that Mr. Green promotes in this case. And so we're happy to do it. We welcome
I can't determine if he doesn't believe what he says or if he's.
Let's break that down. There is a real accuracy on the fallacies that Mr. Green promotes. Fuck does that even mean?
And the thing is he might be right about all of this. It's just, this is not how it works.
No.
You don't get to just say it's wrong. You have to. So.
Yes, but this is his argument.
Not enough tears. Maybe that child should be throwing up.
Please, Judge, please let me do it. But Alessi is now motions king. He is just. You saw him in the argument with Dr. Russell, right?
Oh, he was excellent. I mean, I definitely stand Alessi.
He's solid.
Okay. Did you want to say anything very briefly, Mr. Alessi?
In 60 seconds or less, Your Honor.
Okay.
Thank you for the opportunity. The Commonwealth said a little knowledge is dangerous. I don't know what a hashtag is. I've never heard of what was just said as a hashtag. It's a hash value, and it's a very important concept to get right. With regard to the whole premise and point of my argument, Your Honor, that this is a difference of opinions, it was just made by the Commonwealth foreman. What was said, it's alleged that Mr. Green has reckless opinions. My point exactly, take away the reckless. They're going after his opinions, and it's been stated now by the Commonwealth itself. It's the opinions, and those are not proper for a Daubert hearing. Thank you, Your Honor.
All right.
Damn.
Right? 60 seconds. 60 seconds.
I think we just saw, gone in 60 seconds with respect to the Commonwealth's argument there.
Pretty much. So Judge Bev doesn't ever rule from the bench. She never rules from the bench. She takes the matter under advisement, and she said that there would be an opinion by Monday. Well, we didn't have to wait that long because it was forthcoming rather swiftly. Let's see. Make sure I get this. Yeah, we didn't have to wait long because Judge Bev also did something I've never seen her do, which is to just.
She ruled against the Commonwealth?
Well, one, the Commonwealth's motion to exclude defense witness. She doesn't prepare a separate order. She just writes down here, after hearing and review of written submissions, I've determined that I can decide this motion without any further hearing. So
nice.
So in substance, that means no additional hearing and sorry, you're roasted. They get to give the opinion. Just because you disagree. That's the problem. Just because you disagree is not a basis for excluding an expert.
What if you disagree really strongly, though?
I know. And if you stand up and stomp your feet all the time and you get really upset, that might be a basis for excluding it. I had a similar thought, but generally speaking, in motions I've argued before, I haven't won with that theory.
Huh. Have you tried getting your voice really whiny?
I have not tried that yet. Yeah,
I feel like that might be the missing. That might be the secret sauce here.
I don't feel like it is. I feel like that actually might not go over as well as I think it might. You know what? No, it'll go over exactly like I think it will, which is not good at all. Very, very bad. Not good for me. Anyways, how you doing? How was the week?
I've been sick. I still am. Mrs. Runkle has been really sick. Still is. Yeah. It's been a week. I haven't got my SHOT Show video done yet.
No. Did you take a lot of footage while you were there?
Not as much footage as I wanted, but I did buy a thing that will help me take footage or more footage. I didn't buy this at SHOT Show, but
high-speed camera.
I bought it as a result of SHOT Show. What's that?
High-speed camera?
Nope.
Ooh, that's fun.
It is a gimbal, and I seem to have misplaced a critical part for it, so that's fun. I gotta find that. Where did I put that? Why is it not in the box? But it's not on my camera either. Where did I put it? Anyway,
I think that's a phenomenal purchase. Great purchase.
Yeah, it'll let me do all sorts of fun things for, like tracking and so forth. There's a piece that attaches to the gimbal to the cell phone, so I got to figure out where that is.
Well, while you're doing that, let me catch up on this stuff real quick.
Sounds good. I got to track all my crap down.
AKA the Cat Lady attorneys have now started donating their hourly salary to Karen's defense fund.
Wow.
I don't know why. It's just it feels like Brendan's making these motions. I know you have an obligation to make some of these motions, but holy shit, man. And the reason why is he knows that they're remarkably damning. If one of these opinions gets in, it's kind of inherent reasonable doubt. So Analytical Barney, thank you for gifting memberships. Coral, tomorrow is my birthday. Happy birthday. There's no better way to start celebrating than with you guys. Cheers with an old fashioned from Minnesota. Old fashioned, my favorite drink of choice. So cheers to you. Happy birthday.
Happy birthday. And yes, the, what do you call it? Old fashioned is a great drink. I don't know if it's my favorite drink, but it's up there. I also like a paper plane. Have you ever had a paper plane?
You've told me about this before, but I can't remember what it is.
It's Aperol, Amaro Nonino, bourbon, and lemon juice in equal parts.
I'll have to try that.
So the first three taste kind of like a lemon drop, like the candy. And then after that, they taste like a lemon drop with a slight floor aftertaste. Because it's three kinds of booze mixed together. So you got to be careful with them. They do not mess around. They hit like a truck, but they're very good.
Okay. Rare in history, Jeff's son Connor is doing so Jeff being Legal Vices Connor is doing his first live stream Saturday 8:30 to 9 Mountain Standard Time on his new channel Vice Baby. RIP Jeff at Vice Baby. Please go check that out, guys. It's
Vice Baby is a great
that's a great name. And I hope he keeps up with it. I mean, Jeff built a phenomenal community and it's been a remarkably tragic loss. I
feel like a lot of people are going to at least give him a try because, yeah. And if he's picked up any of his dad's entertaining ability, then I'm sure it'll be a good show.
I'm sure. I don't know how you could be around Jeff without picking any of those up. So, LA, thanks for doing. Remember what we don't know. This is unbelievably important point. None of them are Apple, and Apple doesn't help them. They're all guessing at what Apple source code does. Yes, that is a very important point. All of these, and this is why it drives me nuts when people say Cellbrite is perfect. It is absolutely 100% always right. No, they are reverse engineering Apple's source code and trying to figure out how to translate Apple's backups or the Apple's images as actual discernible application inputs, displays.
Also worth noting is that Apple and Cellbrite are not friends.
No,
they don't work together. Apple does its best to confound a lot of this analysis, and Apple may have just done Cellbrite a real dirty lately. Did you hear about this one? So Apple did a little thing with one of their recent iOS updates, and it really has a lot of like police forensic data examiners and so forth really kind of upset and worried. So here's what it does. Are you familiar with the issues with before first unlock and after first unlock extraction?
Why don't you bring? I don't deal with extractions very much. Usually, I don't have clients that have the funds to get the extractions.
So you get a phone, and let's say you want to get into this phone, right? If the phone has been powered down and you just powered it on, that is the before first unlock state. Okay. It is much harder to get into that phone than it is after the first unlock. After the first unlock, it's basically
there's no background processes running. There's no
sort of way to hook in around it. Yeah. So because after first unlock, it's actually running all this stuff. There is like an unlockable state to reach, if that makes sense. So here's what they did. Because what standard forensics teams do is, like, let's say they burst in my door right now and they seize my phone because they think I'm like involved in like a conspiracy to blow up the moon or something. So what they will do is they'll take the phone and they'll put it into a Faraday bag, because that prevents me from then logging on and going, phone, please wipe yourself.
So did they basically say that the phone losing connectivity puts it back in this state?
Causes it to shut down and reboot.
Wow.
And then goes into before first unlock. So they put these things into the, into these Faraday bags to protect them. And then it's like, oh, right. Enter maximum security mode, please. So basically your phone is now kind of a little like the Batmobile, where it recognizes somebody is messing with it and like puts on the additional shielding. So
nice.
I hope Android matches this, because if they do, I'm going to stick with Android. But if they don't, I may actually be considering buying an Apple for the first time in ever. I mean, I had an iPhone before. I didn't like it much. I replaced it with an Android. I like that better. But I might swap back. So, yeah.
Interesting. Clever by Apple. That's pretty smart.
Oh, it's brilliant, but it absolutely hoses. Yep.
Oh yeah. They rely pretty damn heavily on A, stupid mistakes by you, or B, having that phone in a state where there's vulnerabilities.
Yep. And if this covers, that issue of, like getting rid of the after first unlock availability for them, Like a lot of these things just do not work very well. So yeah, the other thing is be aware of the whole before first unlock, after first unlock thing, because it could, because one of the things that people do nowadays, I'm going to do a video on this, but one of the things people do nowadays is, let's say you're getting pulled over by the cops and you are suspicious of the cops. What do you do? What do people do?
Turn their phone off or yeet their phone?
Well, a lot of people turn their phone on and start recording the cops. And you've actually made it easier for the cops to get into your phone if they want to by doing that.
Yep.
So instead, what I do if I'm like, because, I'm a little paranoid, just power the phone down before you drive. And the best thing about powering the phone off before you drive is that A, it works if you get pulled over. B, also if somebody, tries to phone you while you're driving, you're not tempted to answer it. So, yeah.
Okay. Cat Monkey FPV. The reliability is a matter of fact for the jury. What is not reliable enough to convict McCabe may still be sufficient for Karen's reasonable doubt. We're not, the jury gets to hear the opinion. The expert is the expert. They get to hear the opinion. Patty P, I think Brennan means mixology, not methodology. Hashtag methodology. You might. Math is Grace. Will you cover the mile oral arguments on February 11th? I have trial on February 10th and 11th, or February 12th. I have a trial on 10th and 11th. It's possible that I can cover on the 12th. I don't know. Usually post-trial, I've got a whole lot going on, and I also don't know if they actually live stream or broadcast those arguments. If they do, and someone sends them to me where I can find them, then I'll try to either cover them or do a recap. Katharina Godecki, the uninformed acting like they're smarter than everyone else. He drives me nuts. Referring to Brennan, I assume. Yes. Billy's Momzilla Casher. Pronounced cache means hidden now. Doesn't that describe slot in this case? Cache, pronounced cache, means hidden. Now that, cache. Cache means hidden. Okay, I got it. Doesn't that describe a lot in this case? Yes, a lot is hidden in this damn case. Hello, Nichols. Since watching you folks talk about ADHD, I've had suspicions about my adult sons. My eldest is now beginning his journey to diagnosis. Thank you. I'm very glad to have been assisting in any regard in that capacity, because a lot of people have ADHD and it affects a lot of us. Neurospiciness on any regard, or in any regard, or in anyone's life, can be a very significant hurdle. And you just got to learn how to adapt to it. You can still be successful. I have remarkable ADHD. You guys can tell when my meds start wearing off, like now, because I will go all over the place. Audrey Sova, unplugged phone for the win. Z, please, microdots on YouTube and X, part of defense team. Hang on. Microdots. Is there someone who goes by that screen name? Confused by that. I don't want to be. Maybe because it's late. Please look at microdots. Can someone email me the information so I can take a look at them?
What's this info?
Oh, okay. Microdots, drop microdots is the hashtag name. So it's just a different content creator.
Oh yes, microdots. Yeah,
I'll take a look at that. I've never seen it. Coding Light, You can record on iPhone without unlocking. You can also say, Siri, lock my phone. You can also you can set it up so you have to enter a passcode the first time and Face ID after. Always do this.
Yeah, the thing
Passcode.
is, without unlocking is different than without entering the before first unlock state. Those are different. You can't record without entering the before first unlock, to my knowledge. Or sorry, the after first unlock.
After first unlock.
Yeah, which is not where you want to be if you're facing police. So
I mean, one of the biggest issues where this, and the best example I can give to people who are trying to figure out what this is Apple. One of the very early versions of Apple had this problem where if you would go to your camera and there was a camera icon on the front page, even when you were in lock mode, if you would click that camera icon, it would pull up the camera. Well, on the bottom left-hand corner, it also allowed you to access recent photos. So it actually lets you get into the inner part of the operating system to get the photos by just accessing what they thought was going to be a screened off version for the camera. So they go back and patch it so that you could access the camera, but not get into the photos by coming out of the lock screen.
Right.
Crazy Cat Queen, shout out to Rob and Ian for teaching me about Regina versus Dudley and Stevens. I looked like a rock star in my Law and Society class last week. Awesome. That's cool.
Also, Regina.
Sorry. Regina. Yes, as in the queen. Yes.
Yeah.
Yeah, my bad. It's reading. It's late. Billy's Momzilla, neurospiciness versus spectrum. It makes me feel so much better. I have meant to thank you for a long time. There's no need to thank. I'm glad that you guys are here. I'm glad that you are taking care of yourselves and doing all the things. Let's go ahead, swoop. We've got one more topic to cover. Ian's going to blow his lid, and I've got something fun to share before we get there. So, minis are really funny. And for those of you who might be aware, we went to Arizona to visit my mom for the Thanksgiving holiday. Mini-Mischief 1 decided she wanted to journal while she was there. And in the process of
cool thing to decide.
It was wonderful. There was one journal entry that I thought was just, well, it's worth sharing. And I'm going to put it up on the screen and allow people to read. And you
now,
guys
I
tell
assume
me.
She gave you full permission to share and all of that?
Full permission. Absolutely full permission.
Good. I'm just making sure, because somebody in the chat would come at you if we didn't say it. So
I know.
It's like we're getting that out there so that somebody doesn't.
Permission, but there might not be a full understanding of why the permission was sought and why the sharing is being shared.
Okay.
Let me know when you get to the part that has you doing a double take. Everyone is quietly reading.
Mm-hmm.
I just about died. I said, wait, what the fuck? Since when does the Children's Museum have sex shows?
Rob, you are a child.
Horrible. I almost died. Oh my God. Oh my God. I was like, okay, so here's the thing. I can't call this out directly. I cannot call this out because that then leaves me in a very awkward position of having to explain why this is the inappropriate way of spelling sections. And I don't want to do that. So
Maybe you could just talk about like spelling generally.
Spelling. And I think I just have to write like a sentence like in front of her, and write the word sections in the sentence so that she can see how it's properly spelled, because this ain't gonna fly. I am sorry, but if you are submitting paperwork in class, and for example, you are designated a section and you title your paper as in section, it might not go over well with the teacher. We might get a phone call. So,
Yep, maybe just, sit down and be like, so let's do some spelling practice.
Yeah. So we're going to work on that. And not to be entirely throwing it all on Mini-Mischief 1, Mini-Mischief 2 the other day was sitting in the kitchen and looks straight up at me, stone cold, and says, I know that this is a bad meaning. I know this means something bad. It just holds up the middle finger at me and just sits there and says, I know this means something bad. And I don't think he expected my response, because I was just like, and where did you see that? Because there was this sheer look of absolute horrified panic on his face the second I responded that way. And he this is how great kids are. He comes back and he goes, I made it up. And I was like, in my head, I'm like, bull fucking shit. Nice move, dude. Like, really, you made it up. You made up the middle finger. And then you knew it was a bad word. Try again. Where did you find this? Did a friend show you? No. I saw it in a video game. What game? Okay, maybe it was the TV. What show? I don't remember where I saw it. Just like, at this point in time, I am cross-examining this child, and oh my God. Kids are the freaking best. That was the positive. But sections. There are sections of all kinds of things. And in this instance, there are sections of the code, the penal code, sections of the penal code in New York that are
the what code?
Sections of the penal code.
Have a mini spell it out.
No, you're terrible. So, okay. All right. Last topic of the evening is this. And you remember Supreme Court hearing most recently where the ATF was at issue, and they were arguing on the 80-20 receivers.
Mm-hmm.
And then the government, the argument was made, how slippery is this slope, right? At what stage of the manufacturing process can you still call something a firearm? Like, when is it a firearm? What is it? What is it? Part of a firearm? Is it a component of a firearm? When can you regulate it? At what stage? And then it was the question, well, we can do this because most of the manufacturing process is already done. And all they have to do is a couple de minimis steps. And during that argument, there was this concern of, well, if you can call this a firearm or a component to a firearm that can be regulated, then couldn't you kind of call anything a part of a firearm? And couldn't you kind of regulate anything? And the government's lawyer was like, no, that's not the case at all. We would never go that far. Surprise, surprise, right? Everyone is shocked. Shocked, I tell you, absolutely shocked. Turns out the government, in their response there too, is indeed attempting to go that far. Now, this is New York, which New York loves to play this game of, we want to be the first to regulate anything having to do with firearms, or we want to be the strictest in any. New York plays a game of how many high score Supreme Court hearings we can have. So New York proposes a bill that would require background checks on anyone buying a 3D printer.
Because of course.
The New York legislature is in the early stages of considering a bill that would require people buying a certain kinds of 3D printers to pass a background check. So the bill itself says that any retailer of a three-dimensional printer sold in the state which is capable of printing a firearm or any components of a firearm,
which is any of them,
firearm, anything, any 3D printer that can print a component of a firearm. How are you defining that? Because if a 3D printer can spit out a little bit of plastic into a shape, it can print a component of a firearm.
Yeah, it's any 3D printer. There's no 3D printers that would not be included in this. But they're trying to pretend that it's like, oh, well, it's only some 3D printers. No, it's all of them.
Yeah. Is required to authorize the request and receive a criminal history information. The state would then have 15 days to root through the buyer's information, look for weapons, charges, or other disqualifying criminal history, and make a decision. This would in effect mean that anyone buying a 3D printer capable of printing any piece of a firearm, which is quite a few 3D printers, yeah, like the one that's right there, pretty easily.
The one that's everything. Yeah.
Would have to pass a criminal background check. Here's this. Let me talk about the dumbest observation I have ever seen in my entire life. We live in a world where anyone with access to some 3D printers, the right digital documents, and some practical knowledge can print and assemble an untraceable handgun. Let me rephrase. We live in a world where anyone with technical experience, the right tools, and the right raw materials can manufacture X. No fucking shit. Under this logic, you can regulate individuals that go to buy a piece of pipe at Home Depot. This is so dumb.
I was about to say, hey, here's how you can make a firearm out of Home Depot stuff. And then I'm like, YouTube might not like me explaining, but suffice to say, I could build a gun in like no minutes with, no money, very little money.
It's not. It's so stupid. And the other part about this one is they completely just omit the fact that a lot of people are capable of building their own fucking 3D printer. So now that's the next step. That's the next step. If you are now buying a component of a 3D, this is the slippery slope shit that everyone hates. Oh my God, I didn't even think about this one. Imagine, because Amazon, there's 3D printers for sale on Amazon. Shit, there's 3D printers for sale on Amazon. They're intended for kids that are like $200, $300. They're intended to print little things, but I can guarantee you can configure one of those to be capable of printing a component of a firearm.
I mean, some components of firearms are really basic stuff.
Yeah,
like
a little
sights.
Piece of plastic. That's it.
Yep. I mean, a grip for a firearm is a component of a firearm, but it's not.
Yeah. It's a piece of plastic. It's very easy to do. Print. It's just, imagine going on Amazon and like now you're trying to buy a 3D printer for your kid. A little screen pops up and says, please submit criminal background check history, and then wait 15 days to get your I mean, hell, if you're going to buy your 3D printer for your family before Christmas, now you got to build in a lead time.
To be fair, give the money to the child, and then the child can do the background check because it's for the child. And the child is unlikely to fail the criminal record check because how?
So this is the proposed law. It is one for every person. When lawyers were out on YouTube talking about this argument in front of the Supreme Court, and for every person it was like, of course they can regulate these things. My God, they are so close to being a firearm that you can absolutely regulate them. They're a component. Yeah, they're regulatable. We don't want these terrible people having these things. And then everyone's saying, well, there's a massive distinction between this and regulating just general good old supplies or tools. We're not regulating a process. Fuck off. We all knew you were. Every single person knew you were. It is one step. Every single time you take a step in this direction, you move towards ludicrousy. It is asinine and infuriating. All right, so here's the actual law. Sale of certain three-dimensional printers. Any retailer of a three-dimensional printer sold in this state which is capable of printing a firearm or any components of a firearm, i.e. all, is required and authorized to request and receive criminal history information concerning such purchaser from the Division of Criminal Justice Services in accordance with the provisions of Section 845B of the Executive Law. Access to and the use of such information shall be governed by the provisions of the section. The Division of Criminal Justice Services is authorized to submit fingerprints to the Federal Bureau of Investigation for a national criminal history record check. 3D printer, submit your prints, full background check, 15 days. This is ridiculous. I hope this law dies of the fiery death it deserves. Because the next step is, it's at Home Depot. Any person walking into Home Depot where you can buy things that can be used to manufacture certain things that can cause harm to other people must submit a criminal background check before entering the store. 15-day waiting period before you get to walk into the store and on premises to buy the thing you want to buy.
It's going to be crazy.
Determine whether the purchaser has been convicted of anywhere of a felony or a felony. So mail fraud. Anything. No 3D printer for you. Oh, and it's great. So you basically have to get the affirmative clear from the Justice Services before you can sell a 3D printer. Yeah. No retailer shall sell any three-dimensional printer capable of printing a firearm unless the Division of Criminal Justice Services provides written notification of the determination under this subdivision.
Wow. So if they just decide not to do anything, then suddenly 3D printers are banned?
Oh, this apparently also includes CNC, because while they call it a printer, look at the definition. Three-dimensional printer means a computer or computer-driven machine or device capable of producing a three-dimensional object from a digital model, which would actually encompass a CNC.
So basically it's illegal to be a machinist if you happen to have a criminal record?
Mm-hmm. Unless you get again, this is just, it's a proposed law, but I'm sorry, this was predictable based on the stance that's been taken. This is insane. I understand the need and the desire to prevent certain atrocities from happening, but this is not the path. Not the path. So I guess we shall see where this goes, if anywhere at all, but I can guarantee you this is not going to be the last state to try this. Another state, another congressman or state senator literally probably saw that article and was like, oh shit, I can do that. Let me copy this verbatim and submit this as the law tomorrow.
Yep.
So I hate this path. It is dumb. It is the very definition of slippery slope. It is horrible. So, and yeah, this is the other part about it. The distraction is the guns, in my opinion, but impact to science is devastating. Yeah, if you take away, not just impact to science, impact to American ingenuity. I mean, part of this is the process for just, how do you think we get engineers? By having people that tinker and do shit. If you start regulating the hell out of anyone who wants a future in engineering or manufacturing or fabrication, you're out of your damn mind. Question, would it apply to Cricut craft machines? They can cut cardstock. They can actually cut wood. So there's an argument.
And leather, yep.
And leather. And you better believe that if you give any certain entity within the executive branch of a given state, if you give them the authority to set the definition and the parameters of the definition of what a component is and whether the machine is or is not capable of printing that, they're going to expand the definition beyond. And here's the thing. Going back to that definition says, I want to read it again. It was
I bet you could print a usable trigger out of a or a grip out of a cricket.
Oh, absolutely. Absolutely.
So,
because the other part was, let me see, it was and here's the thing. What does it mean under this statute? 3 bits computer, or a computer-driven machine, or device capable of producing a three-dimensional object from a digital model. So now the computer, not just the machine you hook it up to. Are we not regulating computers that are capable of doing this?
I mean, Canada has banned the data for firearm stuff.
It is wild to me. This is just insane. And people are looking at here's the mistake, and here's one of the mistaken arguments. Or are they piggybacking the Luigi Mangione thing? Yeah, but this is not because of that. Everyone who's saying this is because of that is throwing up a massive smokescreen. No, anything that
it's a little of both.
It is, but it's an excuse they're piggybacking on.
Yeah.
They were looking for this excuse all the time. It's just very frustrating to see. Angelic Mike, Android updated today. Lock if stolen or lost. See, Android got it. Julian Whelan was Gimlet's Ian character in D&D. Seems fitting. Yeah, Gimlet kind of Ian chose. Yeah. Audrey Sova, this would violate the first expression in addition to the second. New York is just like, hold my beer. We want to break the high score for things up on appeal in Supreme Court. Morgan, by that logic, they should background check regular printers because I can print making instructions. Yeah. H Scorpio, background checks on plumbing supplies. When? Next year. Megan, aka Meg, is autistic. My lock screen is a pic of my 3-year-old niece showing me an ouchie on her middle finger. Best photo ever. I've got one of those of my niece as well, literally pointing to the ouchie on their middle finger. Sean, potentially criminal. Wait until they learn about the Louis submachine gun or how 3x4 pipe is 12 gauge. They know these things, and they're just waiting for an excuse to try and write a law that they think they can get through Congress. I mean,
that said,
as well as anybody.
If you've ever shot a Ludi, God, they suck.
But by the logic that they're employing here, anything.
Yes, but it does suck. Ludi is the worst.
Never shot one.
I don't recommend. They suck.
What happened to Luigi? Explain this. Yeah, they're using this as the basis for this law. It's just it's just dumb. Krista, limited edition, sending love and light to you guys in the chat. Thank you very much. Minnesota knows what the process for kicking states out of the union. Very long and arduous. And actually, there was a Supreme Court case that you actually couldn't. No, that was US v. Texas, and a state couldn't voluntarily leave the union. That was actually during some of the Civil War discussions. It's not easy. Morgan, or, and hear me out. The criminals drive to another state and buy one. Crazy, right? Yeah. Alias, what would this mean if you live in another country? Nothing. This would only regulate purchases in New York. Now, if you were buying from a New York manufacturer, they would have to do this for any sale they made, regardless of where you lived. Katrina Turner, there's a build your own gun subscription service. Yes, there are lots of these things. Audrey Sova, remember the CRS YouTuber who was selling metal cards with etchings of an AR switch? They thought they were protected by the First Amendment. Also, any laser tech.
Mm.
The amount of technology that you can regulate on the it gets ridiculous really quick. And this is one example of how ridiculous you can make these arguments. Wait till they try to register printers and manufacturers. This is one step removed from that. Sean, my winter project is a 3D printed 40mm launcher. That's a winter project, man. That's quite the undertaking. So it is it's a weird world we live in. Very weird world indeed. So that's something that we're going to keep a track of. So we covered all of our topics. It's been a long stream. Ian, Ian's not feeling well. You doing Monday?
I mean, assuming I'm healthy enough, then yes. I also got to do videos. There's a new version of the Elf license. I've got a video that's not doing well right now. It is the new Janet video, and it's not doing well because, of course, I posted it at the worst possible time, which is when everyone is streaming, but I didn't want to post it on the weekend. I should have probably waited till Monday. But
driving home, and I saw that notification come up, and I was like, I really want to watch this, but I still have to finish watching this stream that I'm watching so I can have timestamps.
Yeah, no, that is perfectly, reasonable. What is it? She got destroyed. Just absolutely destroyed. I mocked the hell out of it, but can I share like a
of course you can.
Can I I'm just gonna find a what is it? Let's just find a little
Morgan says thinking of business possibility, set up a huge 3D printer store right on the other side of the state line. Have all the disclosures printed in signs and big bold text about New York and the laws in New York, but yeah, it just drives people from the state.
So I got the final determination up here.
Okay. You've got the buttons.
Let me just I gotta figure out how to make the buttons button-y, I guess. Present, share a window. There we go. Final determination. Dismisses the claim against respondents with prejudice. But there's some really exciting bits in here. First footnote. The first footnote is long, so I'm not going to read the whole thing. But the first footnote involves the judge basically saying neither side followed the rules for what how to file documents on this. And now here's the fun thing. The respondents, which is the hosts of the Do We Know Them podcast, Jessica Vasquez and Lily Marston.
Mm-hmm.
The respondents are just people, like just ordinary people.
Yeah.
On the other side is Braun IP Law, so a law firm, who is also represented. And then there's Janet, a lawyer, and then there is a lawyer representing that. And so when the board is like, nobody followed the rules here. It's one thing when you've got that as like everybody is just some idiot.
Yeah.
But it's a different thing when one side is a lawyer. Like one side has like multiple layers of lawyer. That's like this whole onion of lawyers.
Yeah.
And there's some things in here that got a bit of a sneeze there. So I go through this and there's so many mockable elements in this, but there's some little bits where I just want to get your thought here. I'm just trying to find it in this. I'm just going to do a little Control F. So here's the line, or here's one of the lines, and just tell me how you'd feel about this line in a thing describing you.
Ouch.
That argument is meritless and undermines claimant's credibility.
Ouch.
As a lawyer.
I mean, you couldn't think of a kinder, sweeter, gentler person to possibly receive that. Just,
But like, for the chat, there are professional implications of a lawyer being
credibility,
found not to have credibility. And the other thing is there will be in the federal case, if I'm the lawyer in the federal case, I am mining this thing for quotes.
Oh my God. Yeah.
Because
absolutely,
when she gets up for her deposition, assuming that the motion to dismiss doesn't just go goodbye, they're going to be like, so, has a court ever found you to lack credibility or had any concerns with your credibility?
Yeah.
And
you better believe that every opponent to anything she ever files in the future is going to say, Braun has been found by a court to have made meritless arguments in the past, and directly cite this.
And yeah, I mean, you gotta have some thoughts that like maybe a lawyer wouldn't find this unless, say, there's some jackass on YouTube with a substantial following who puts out videos about it using her name.
Yeah.
Because in that case, somebody who Googles her might find it. And the best part is she can't even go with defamation because this is a finding of the copyright board.
Yep.
That I'm just reporting on what the copyright board said, which is your argument is meritless and it undermines your credibility. Like, oh,
yeah, that hurts a lot. That hurts the soul. Not my soul, but definitely hers. Wait, hang on. Let me pause. If one to be had, a soul would hurt.
And somebody said, why would you Google Jeanette? Here's the thing. If you were looking to hire a lawyer, you might Google the lawyer. Right?
Lawyers Google each other all the time.
And absolutely we do. If I'm going up against a lawyer, I might very well check their past cases. I might Google them. Yeah. I mean, sometimes like I Googled one lawyer that I was up against and I saw a bunch of ethics complaints. And it was really useful because right from the outset, I made sure not to have any phone calls with that lawyer and everything was done via email and in writing. And you bet that came up later when they were like, oh, I never said that. And I'm like, oh, I'm quoting you. And they're like, and I'm like, yeah. And the quoting you will continue until the bullshitting stops.
Ooh, you just got to pick that highlighted phrase and like throw it as part of the thumbnail. Yeah.
It's a little too wordy for the thumbnail.
Yeah, that's true. You could just put like the lacks credibility thing. Also, I have to do this. I have to do this. Now, the chat was yelling at me. I don't know why. The chat house somehow pretends that I haven't already, emphatically congratulated you.
I'm pretty sure you congratulated me like before I was. like before I was even off the stage. So yeah.
Also, objectively, I mean, my feelings were a little bit hurt because that photo I took of you in the tank is one of my favorite photos, or the other one that was your profile for a while where you were standing like just looking at the tank. This one wins, I think.
It's a good picture.
It's really good.
But you're right about the tank photos, also solid.
Yeah. So
yeah,
congratulations.
Did you see my speech?
I did.
My speech starts off with, I don't have a speech written because I did not deserve to win this.
I mean,
I was figuring my speech out as I was walking to the stage.
It's a good thing you're a lawyer. It's a good thing you're a lawyer that argues on their feet.
Yep. It was kind of like when the other side is like, objection, hearsay. And you're like, oh, I can actually see that argument. I have to respond to this. Oh my God, I did not see this coming. Let's figure this out. So yeah.
Well,
yeah.
Congrats. It was really awesome. It was very well deserved. It was really cool to see. I thought it was great. But okay, let me get these last three and then we'll wrap up. Okay.
Absolutely.
The squirrel doesn't get ridiculous. It started that way. Yeah. Some of the regulations have. Helen Nichols, congratulations on the Gundy win. Ian, congrats again. Torin 3, FYI, fingertip healing well, no permanent damage. Very glad to hear that. I don't know if you saw that. Torin had to run in with a router. So,
ooh. And
very glad that's healing up.
The reason I won was that the fan base was dedicated, and I think they solved the whole like they had a voting system with like referrals, and I think they basically solved it.
I think chat shows up. That's the thing. So I thought it was awesome. It made me very happy. Very glad to see. Okay, guys, we are going to go ahead and wrap. It's been going for 5 hours, another 5-hour stream. A lot of fun. Hit all the topics, all the discussions were had. Ian is likely going to be streaming on Monday. If he is not, he's going to be check out his other video. Check out the video on Janet Braun. I'm probably going to watch a little bit of that before I go to bed. Please do that. And
I do have some people asking if I won the bunkie. I did not win the bunkie. They got somebody else's name. That person was ineligible. So they did another draw. And they drew like 3 names and none of those names were me. So even if the next person is ineligible, there's got to be like 4 ineligible people. So yeah, I do not have a cabin plan right now. I got to figure all that out. So yeah.
Well, we'll get the bunkie in the next go around. Morgan, yes, chat definitely understood the assignment. They always do. Okay, guys, we're going to sign off. Thank you for being here. Thanks for catching another Friday stream. Hope you guys have a great weekend. Hugs to all. Love the mods on your way out. Please hit the like button. Don't forget to buy some Girl Scout cookies. Link in the top of the chat. I'll put it in the video description as well. And we will catch you guys next time. Have a great weekend. Go make something. You'll feel better. All right. Night, guys. Bye.